এখানে না
Prohibitions matter for orders, items 1 and 2.
এটা নহয় জানো? Yes, Mr. Longchar.
Malo,
Yes.
I is for continuation of 68 days delay, Malo.
Yes. Notice has been served. Under response number 5.
It appears not.
State Council, yes, Mary. Miss Mary is available.
Malo, she must be in other court.
What is your grounds?
Malo, I want.
Okay, we will conduct the delay.
Para 6. After I.
Heard Mr. M.T. Longchar, learned counsel for the applicant. Post learned state council for the opposite party number 124 is found absent to the on of the instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 68 days, which period of delay is stated to have occurred in preferring the accompanying review petition against a judgment and order dated 9/12/2024, passed in writ appeal number 20 within bracket K 2024. Full stop. We have gone through the statements and amendments made in the instant application, more particularly, paragraph number 6 thereof. Full stop. Having gone through the same, we have the considered view as the petition applicant has been able to make out, has been able to show sufficient cause for the delay, for considering the delay of 68 days. So accordingly, the instant application is allowed. So, yes, on the review petition.
My lord, I may be allowed to take step for respondent number 5.
No, first you satisfy us on what ground?
My lord, the applicant, he wants the relief given by the Supreme Court in the Chaku.
Where is your ground for review? Ground number
Para 5.
1 to
My lord.
4,
My lord.
1 to where is your ground
My lord.
in your review petition?
Para 5.
Para 5.
My lord.
Jago.
My lord.
The Jago decision was delivered on 20/12/2024,
Right, my lord.
and the judgment in
9.
respect of which you have sought review
9.
was delivered on 9.
12.
12.
Yes.
So can it be a ground of review?
My lord, I may given the liberty to approach this court.
Liberty to?
Approach the single judge on this ground. If- by closing this review petition, my lord. As your lordship has pointed out.
Whether it can be a ground of review, we'll decide. Under Order 47, Rule 1, CPC, whether
No.
it can be a ground for review.
My lord,
It is a subsequent judgment. Jago judgment is a subsequent judgment.
yes.
It cannot be a ground for review.
My lord, that may be noted, my lord. That will be sufficient for the petitioner
Yes.
so that he can approach the red court.
That is up to you.
My lord, it left
That liberty cannot be granted.
my lord.
There is only one forum available for you.
Liberty may not be granted, but I am submitting that let that aspect of the matter which your lordship has pointed out may be reflected in your lordship order.
Okay, we'll think it over.
My petition, but that aspect of the matter may be kindly be noted, reflected, so that
Okay, we'll find out whether review is possible or not.
no,
We'll find out whether review is possible or not.
my lord, no, as your lordship has pointed out.
So we'll close out.
My
We'll close this review petition.
my lord,
Yes.
my,
The review is to be dismissed on the only ground that Jago decision is subsequent to the division bench judgment.
much obliged, my lord. Much obliged.
May it please allow. Lord, may I be permitted to move a very urgent application, my lord. I am a dealer of an LPG. Now, my lord, initially a suspension order was given to me. My lord, no apparent reason, no cause has been shown, my lord. Now, my lord, I have received another notice yesterday whereby they say that they will inspect my premises and they will take back my cylinders and all. And they have also directed me to keep sufficient balance in the PAD account, which we maintain, so that in case of recovery, at least even on the control order also, my lord.
Can it be tomorrow?
Look, today itself they are going to take action, my lord.
Okay.
And my lord, that trade article order of 1982, that itself emphasizes how the action is to be taken. Everything has been flouted.
In respect to item number 2, Lordship,
Hmm.
the pleadings have already been completed. Lordship may have the matter immediate after.
No, it is not called yet. It is not yet called. Let the item number 1 is called.
Deep level.
May it please, your Lordship, I am paying for listing a motion matter tomorrow, my lord.
Hmm?
Motion matter for tomorrow, my lord.
What is the
My trade license was cancelled. Against that, I preferred an appeal last year, my lord, October month. My appeal has not been decided till date, my lord. Much obliged.
okay.
May I please, your lordship, prayer for listing. The matter was
Motion
No, admission.
after vacation?
Blessed.
Give it to the court master.
For permission of listing tomorrow morning.
Hmm?
For listing of listing the
Motion.
matter tomorrow motion.
What is the subject matter?
Subject matter is the bill amount of the petition.
Bill amount?
Yeah. Pending minutes since.
After vacation.
Well, only
Only urgent matter. Bill amount. When did you execute the work?
2024.
2024. You can wait. Yes. It is not urgent.
May it please your lordship. My lord, I beg to mention item number 28 of contempt matter, your lordship.
Item
Concerning
number?
28 of today's list.
Yes.
Contempt matter.
Yes.
When I consulted the petitioner, I'm the petitioner, consulted the petitioner, he said that I think he noted that whether the amount has been received or not, he noted, but the person is, your lordship, under dialysis and in a serious condition right now. So to verify properly, I need to consult the family actually, whether, so let the matter be listed rightly after vacation.
Okay, on the prayer of Mr.
My name is A. Narzari.
Agent Narjil Land Council for the petitioner lays the case on suits
May
in
the
order to complete his instructions.
1105.
listing a motion matter, lordship.
What is the
Matter,
subject?
matter related to lordship, renewal of trade license, lordship.
Okay,
Tomorrow, lordship.
I am also praying for listing of motion matter tomorrow, lordship, wherein the private respondents were allowed to leave the PDS item, lordship, without there being any tender, lordship. Tender was expired in their 2023, no monthly basis, lordship.
okay.
Yes, your lordship. I beg to mention item number 31, lordship. In hearing column, lordship.
31.
Yes, lordship.
Yes.
Seek for adjournment, lordship.
You are for a petitioner?
Yes, lordship.
Miss
P. Lamu, lordship, on behalf of B. Kaushik.
Land Council on behalf of Mr. B. Kosik, Land Council for the petitioner has made a prayer for adjournment.
There is an interim, lordship. I will
The
continue.
case is submitted that you have, it is Mr. A. Gogoi, Land Technical Senior Government Advocate for the state. Respondent is in attendance and has submitted that he is in position to pray for adjournment, close to as sought for. And I to what the land of the parties, leaves the case after 4 weeks on the date to be fixed by the office. Yes.
Daily list for motion. Item number 1.
May I please, your lordship? Your
Yes.
lordship, this matter pertains to non-compliance of this honorable court order.
Mr.
dated-
Your name, please.
Your lordship, Y.N. Mohanto.
Why Mount Land for the petition first. This contempt petition is filed illegal. Non-compliance of the direction made in an order dated 17 to 2025. Passed in a petition, Commandable PC number 5505/2023. It is referred that the order dated 17 to 2025 has been duly brought to the notice of the respondents on 6/11/2025. First of issue notice returnable on sense if speed post within 2 working days from today.
Much obliged, your lordship.
Item 2.
Yesterday, petitioner has also filed a reply, lordship. Since pleadings has
Oh.
already been completed, lordship, may the matter.
Okay. Mr. Kashyap. Okay, we'll issue notice returnable immediately after vacation.
Yes, lordship.
Heard Mr. T. Kashyap, Land Council for the petitioner, and Mr. K. Kolita, Land Standing Council, Oil in the for all the
All
respondents.
right.
First of Land Council for the parties have submitted that the exchange of housing is complete. First of let notice be issued as the exchange of pleading is complete between the parties. This is made returnable on
Except 24, lordship.
22nd, your lordship.
not that early, 27th.
If lordship 27 by senior may be out of station, 29th or 28th.
You have
Except 24, lordship.
20. 22nd.
Yes. Hello.
Item 3.
As all the respondents are represented, issuance of formalities is dispensed with.
In this matter, I have a very limited prayer. Petitioner society was the highest bidder. Yeah, so as far as fishery rules, he is entitled for settlement. But as the fishery society is a new society, so he could not submit the 3 years balance sheet. So whether that is mandatory or not, we have already submitted our representation. Let them decide.
Mandatory because of now that government notification.
So that is why
Government notification and
Yes.
that has been that has received approval of the Honorable Supreme Court of India, that this notification is to be part and parcel of every tender notice of fishery settlement. Now, I think that notification contains the condition.
Yes,
Then,
but the society was a new society, that is why they could not.
so that is one stability and financial soundness of the society is a matter in a tender process. Though it is 60%, though the laudable objective is for benefit of the fishermen, but still, for the purpose of revenue, there are two aspects. Whether this is to be, we can issue notice only. We cannot.
Or let them they dispose of the representation, we leave it to. Dispose it of.
What, that is a different issue. I don't pass such kind of orders.
Well,
When the tender process is pending, your bid will be given consideration.
Well,
That's all.
well.
If you are aggrieved after rejection,
well,
so why will preempt? Let
Well-
the decision-making authority take the decision.
well,
We'll close this. You consider his bid.
Considering his representation, Lordship.
Huh?
Considering his representation.
No, their process will be settled.
Yes. No, it will not be settled for 2 months, Lordship, due to election.
So you process, because he has participated by submitting the
Lordship,
bid.
Lordship.
Let them consider. If
Yes.
it is considered well and good
well,
and accepted, better,
yes.
and rejected, you have appropriate forum.
Lordship, Lordship.
Heard Mr. N.K. Kolita, learned counsel for the petitioner. And Mr. P. Sharma, learned standing. It is AFDC or government?
No, Fishery Department.
P. Sharma. Now, standing counsel fishery department for the respondent number 1, 2,
3 and 6.
6, and Mr. K. Goyal, and additionally senior government advocate
4 and 5.
for the respondent number 4 and 5. Post of. Yeah. The petitioner is a registered cooperative society. Is a cooperative society registered under the provisions of the Assam Cooperative Societies Act 1949/2007. Full stop. It is stated that the society has been registered. Petition society has been registered. Two 2007 report, 1949, right? On 5/2/2024. Full stop. And the certificate of registration has indicated the area of operation of the petitioner society. Full stop. The petitioner has projected that 100%. The petitioner society has been formed by members, by 100% fishermen members. Full stop. The case of the petitioner is that by a tender notice dated 22/8/2025, the respondent number 4 invited tenders for settlement of a fishery named Dibru Brahmaputra Mean Mahal, located in Dibrugarh district. In response to the tender notice, the petitioner society submitted its along with all the requisite documents, as called for by the tendering authority. 7 accept. The 7 accept a copy of the waiver condition.
Conditions, my lord,
Now, which paragraph you have said?
paragraph, my lord. Regarding, my lord, that
Synopsis.
notification is not annexed, my lord.
No, no. Will not let them consider, but what is your ground?
My ground, my lord, lordship will see,
7 accept.
this is the highest bidder,
copy.
my lord.
As we have not considered this.
Paragraph 10, 9 and 10, my lord.
7 accept a copy of the balance sheet for the last 3 years. Post law. The bids, the tenders. After the last date of submission, the tender box was opened on 22/9/2025. Post op. Apart from the petitioner society, 3 other bidders have submitted their bids in response to the tender notice dated so and so. Post op. After opening of the tenders, it is found out that the petitioner society has emerged as the highest bidder, as it's offered value of rupees 18 lakh per year for the period of 7 years is more than the offered values, that the values offered by the other 3 participant bidders. Post op. As the tender process initiated by the tender notice dated so and so has not been brought to a logical conclusion, and with an apprehension that due to non-submission of the copy of the balance sheet, the petition society has approached this court by the instant litigation on the premise that the petition society might be treated in a discriminatory manner in the process of evaluation of its bid. Post op. It is a submission on behalf of the petition society that the petition society, having been registered in the year 2024, cannot have the balance sheet for a period of 3 years, and the same should not be treated. And for on that ground only, the bid of the petitioner society should not be treated as a responsible. Mr. Sharma, Standing Counsel. Fishery Department has submitted that the tender process initiated by the tender dated so and so is yet to be brought
As per Rule
to
12,
its
Lordship.
logical conclusion. Full stop. He has submitted that the process, the evaluation of the tenders received in response to the tender notice dated so and so would be done strictly in terms of the Assam Fishery Rules
12.
1953,
Rule 12, Lordship.
and more particularly, Rule 12 thereof. Full stop. as the petitioner society, as the tender of the petitioner society is yet to be, as no final decision as regards the tender of the petitioner society has been uh, uh, been made, comma, he has submitted that the petition is premature at this stage. To stop. After publication of the tender notice on so and so, 4 bidders have submitted their bids. To stop. As the fishery named so and so is a 60% category fishery, comma, the final decision. So, sorry, the tender settling authority is the state government in the fishery department. First of, the district commission, Dibrugarh, is the primary authority who, after opening of the tenders received, comma, has prepared a comparative statement. Post of the tender, the district commissioner Dibrugarh as the tender inviting authority is required to send the bids to the fishery department, the government of Assam, for taking final decision in the matter. First of, as the tender process initiated by the so and so, tender notice dated so and so is yet to be brought to its logical conclusion, comma, and no final decision on the tender submitted by the petition society has yet been arrived at, comma, the petition is found to be premature at this stage. Post of. The respondents are expected to bring the tender process initiated by the students to its logical conclusion as expeditiously as possible. Post of, if post of, in the event the petitioner society finds itself agreed by the final decision taken by the tender settling authority in any manner, the petition society is at liberty to approach to avail appropriate remedy as permissible under the law. The aforesaid observation, the repetition is closed.
Item 4.
May I please, Your Lordship?
Yes.
This petition has been filed for the supervision charge which has been deducted from my admitted bill. It was a contract. The contract matter, Your Lord. Lordship, initially the contract was awarded for 2 years.
Supervision charge,
Yeah, supervision
8%.
8%.
What is the amount?
It's around 4 lakhs.
61,000. Yes, Mr. Singh and Chakraborty.
First of all, my lord, this is out of a contract, my lord. As per the judgment of State of Kerala versus my lord.
Korean,
Yes, my lord.
Kalathil,
Korean, this is not.
we are admitting.
Yes, sir.
Then, but if we go by that, then everything will be stopped.
Secondly, my lord, there is an arbitration clause, my lord. Page 116, my lord. Clause number 22.2. Dispute resolution, my lord. Relevant 20.2.1.
One.
29.2.1, my lord, page 116.
116. 29 point?
Or 29.2.1, my lord, relevant. May I read?
115.
In case the parties are unable to resolve any dispute through good faith discussion, either party shall be entitled to refer such dispute to arbitration by serving notice on the other party. In cases where the claim amount is Indian rupees 50 crores or less, the arbitral tribunal shall consist of a sole arbitrator to be appointed multiply by both parties. Mutually.
What is the case about? Yes, Mr. Counsel. What is your case?
My case is that the contract is over. Initially, the award was given for 2 years, but in the meantime, on the 5th month, it was terminated. I'm not agreed with it. This is as per the contract rules and regulation has been done. But nowhere, either in the e-tender or any contract, in any agreement, there was a mentioning of the supervision charges, which has been deducted at the rate of 8%.
Okay. Where it is reflected that supervision starts?
Yes. Now, 1 second. Page 177, that's the bill.
177. Sanction order.
Is it that the bill which has been is the sanction order of the bill from the FCI, your lordship? Forwarded to that. See the push. And next
Where is the
page.
provision in the contract? Supervision starts.
No.
Hello, clause 15.
Clause?
Clause 15, minute. Clause 15. not
Page?
five.
Page.
Page, my lord, just a minute. 42, my lord. No, not 40. Not 40.
7-4.
It's 94, my lord.
Which clause?
Clause 15, my lord, payment. Page
1
94.
point, 15 point?
15, my lord, 15.1.1.
1.1.
Yes.
Just a minute. Bills.
Yes.
Sorry, monthly bills.
And relevant, my lord, page 195, 15.1.4.
195.
95 is appearing at page 94.
Page 95, my lord.
90.
Huh?
Page 95,
Clause?
15.1.4.
15.1.4 is at page 94 in my case.
90.
In my,
90.
in my copy of 95. 95.
95.
Read the clause.
Yes, my lord. The corporation shall make payment after realization of the amount from the depositor and upon receipt of a correct bill submitted pursuant to clause 15.1.1 and 15.1.2 to the contractor's nominated bank account as notified in writing to the corporation. The corporation shall not be liable for any interest on any bill outstanding for payment. Now, my lord, what happens, my lord? There is a supervising charge, my lord, that has to be deposited by FCI to us. So, my lord, FCI is yet to be deposited. my lord.
Where is the supervision
Kindly-
charge? Where is the clause
Yes, my
regarding
lord.
super?
Kindly come to page 178, my lord.
178.
Yes. This is another sanction order from FCI.
The supervision charge claimed. Somebody has claimed 8%.
Yes, my lord.
What is the basis?
The
Source
source, my lord,
from the contract. Where is that?
No, the payment, my lord, payment condition, my lord. It covers everything.
There is nothing. This
So far as
This
15.1.
nomenclature, supervision charges,
Yes, my lord.
there is no mention about this in the contract agreement.
My
If
lord,
this is beyond the contract agreement,
yes,
then
my lord.
definitely this decision is arbitrary. Supervision charges claim that 8% in each of the invoices has been withheld as per FCI RO Shillong direction. Matter is pending with its FCI headquarter for decision. So itself is doubtful. Heard Mr.
B.
B. Dev, Learned Counsel for the petitioner. Mr. R. Chakravarti, standing also Central Warehousing Corporation, CWC, for the respondent number 125, and Mr. B.K. Singh, standing also FCI, for the respondent number 6. Full stop. Para, the petitioner has stated that pursuant to a tender process initiated by a E-tender document dated 5/7/2023 for appointment of regular handling and transport contractor for handling of food grains and allied commodities, the petitioner submitted his bid, and after having emerged as a successful bidder, who is your the petitioner was awarded the contract
for award is
by a letter of award
appointment letter
21/7/2023.
170. Appointment letter is 73. Your lordship.
21/7/2023.
Okay.
Page Annexer B
Yes, your lordship.
for handling pork of food grains at railhead or RH within bracket Udaipur and transportation work from railhead within bracket RH Udaipur to CW FSD Chandrapur WEF 24/7/2023 to 23/7/2025. Full stop. Para. The contract work was, however, terminated in the midstream by a notice, termination notice dated 1/12/2023. Full stop. The petition is aggrieved
24/7.
aggrieved by deduction of an amount of rupees 4 lakh. $61,861 from the final bill amount, on the final bill sanctioned, released by a sanction order dated 16/12/2023. Post of referring to the sanction order, the Learned Counsel for the petitioner has submitted that the said amount has been kept withheld as supervision charges. Post of the sanction order has mentioned that the supervision charges at 8% has been claimed in each of the invoices. As per FCI direction. Full stop. The said decision to containing that the said withholding, the withholding of the sum of rupees 4,61,861 towards supervision services at 8% if illegal and arbitrary if the contract agreement executed between the parties. The petition has preferred the extended petition. You should notice returnable on so and so as Mr. Chakraborty 1 to 5 and seeing 6 no formal notice extra copy you need to working days from the
2205.
Right.
Item 5.
Wait, please, Your Lordship. The petitioner before my lord is an RAT, my lord, Rural Energy Technician. Under the National Biogas Manual Management Program, he was engaged as a turnkey.
Heard Mr.
J. Singh, my lord.
J. Singh, Land Council for the petition and Mr. R. Gugoi, Land Standing Council.
Environment
Forest and Environment Department. For
One,
the respondent number 1, 2, 3.
two, Additional Chief Secretary Government Office.
2, okay.
I'm for 3,
1,
1 and
3.
3, Your Lordship.
1, 3. Mr. M. Setia. Land Junior Government Advocate for the respondent number 2. Poster. Nera. The petition has stated that he being a trained and registered rural energy technician within bracket RET, comma, installed 1820 biogas plants under the National Biogas and Manure Management Program NBMMP during the financial year 2017-2018 after being engaged as a turnkey worker. Post-op. The petition has stated that he had executed all the jobs assigned. Post-op. For 1820 plans installed, comma, the petitioner is entitled to receive an amount of rupees 27,30,000 post-op, as despite repeated approaches and representations, the state amount stating that despite stating that the petitioner has approached this court seeking a direction to release the same amount. Post-op. Issue notice returnable on so and so. As Mr. Gogoi for 1 and 3, Mr. Chetia for 2. Finance. No finance.
That is, 4 is also there, is not that it's not represented today.
And who would receive 4? Central Government Council. I think CGC. Mr. K. Gugoi, Central Government Council for the respondent number 4. Extra copies. 2 working days. Petitioners shall furnish a copy of the petition along with an annexure to the Land Standing Council, Finance Department, within 2 working days for purpose of service of notice upon the respondent number 5. This is the case on such.
25.
Item 6. May I please your lordship? Lordship, last occasion instruction was for four. Lordship.
Your lordship, my senior is on her legs in another court, so the matter may be taken up after some time.
Okay.
Item number 7. Last occasion instructions were short format.
Yes.
Lordship, I saw the verbal instruction. They said that this license has to be there if you want to register in a label, Your Lordship. Here, the issue is that he has no label. So the Superintendent of Tinsukia has not renewed his license. But as per the commissioner, as per his understanding, as per verbal instruction, is that a license has to be there. First, a license should be there. Thereafter, the registration of the label will come. So if there is no license, registration of the label won't come. So now, if his license is not renewed, this means he has no license. The license is to in effect, Your Lordship. So most probably this order by the Superintendent of Excise is not completely correct, Your Lordship, for not renewing the license just because the registration of his label has been stayed by a commercial court.
Regional level.
Just the label,
Ah.
not the license and anything.
What is this commissioner order?
It's 51, my lord. It is also
Page?
51, my lord. It has also suspended my brand that he cannot, my lord. I also put to challenge this order, my lord. On wrong interpretation of this commercial court's order, my lord, he has suspended the brand also, my lord.
That is a different issue.
Now, I put to challenge both these orders, my lord. This letter at page 57 as well as this page 51. I put to challenge both these letters, my lord. Because, my lord, commercial court says only label, my lord. It does not speak of my brand, my lord.
No, that will
My lord.
require some
My
examination.
lord.
That cannot be.
My lord.
Will that require some examination?
My lord.
But the rule says that for renewal, you have to have a brand. That's the problem we are facing. For the renewal, there should be a brand. He has
Which-
no. Some
107, my lord.
Rule 615, Your Lordship, of the Assam Excise Rule.
615.
615.
Just it.
615. The next page, provided that the application renewal, Your Lordship. After clause 4, 615 after clause 4, provided the application renewal.
Just a minute to understand.
Yes.
The capital or seal ROPP. Yes, which sub rule?
So after sub rule 4, Your Lordship. 615. Provided that. Starts with the word provided that. Then it comes to rule 5, sub rule 5.
No, whether these two concepts are different, license and registration of brand.
Yes.
Huh? So sub-rule 4 says the whole rule 615, it speaks about label.
Level.
Then sub-rule 3, the registration shall be for a period not exceeding 1
year.
year from the first day of April to the 31st day of March. Then 4, application for registration of a brand and label of country spirit under sub-rule 2 shall be made to the Excise Commissioner at least 2 months prior to its manufacture or sale or offer for sale. Proviso. Proviso is definitely to be read with the main sub-rule.
Sub-rule.
Provided that the application for renewal of the existing brands and labels shall be submitted to the Excise Commissioner by the month of February every year. Right?
Right.
Now, impugn order, page 57, it speaks about license.
License.
That is what I am.
It's only speak out license, not about the brand. This is, we have temporary suspension of a license.
That is by the commissioner.
Commissioner.
The brand has been suspended by commissioner. Now, he appears to have gone one step ahead. Where is the license provision?
127.
127.
127. Sorry, madam, 128.
This is renewal of
renewal.
license. And where is the provision for license?
114, Your Lordship.
114.
114.
And this is country.
This is country. This is actually for the bottling of portable country spirit, not for sale.
Where is your license?
At page 24.
There are 3 different licenses. First is lordship find page 16A, my lord. My lord, it is for construction for bonded warehouse, my lord, for storing the spirit, my lord.
Bonded warehouse. Bonded warehouse thing is gone, right?
Now,
Now.
lordship,
Yeah.
Or
21.
if it is manufactured, it should be
Yes,
there.
It should be there.
Page 10, lordship, page 21, my lord.
A license for reduction
No,
of
ENA.
ENA. ENA means
Extra neutral alcohol.
Alcohol, my lord.
extra
Neutral alcohol.
alcohol for manufacture of country spirit.
And then page 24, my lord.
For bottling of potable country spirit.
Yes.
Now, what is the license condition here?
Page 25, Your Lordship.
25.
Page 25. Serial number 5. Each bottle bears a label.
Previously approved by the Excise Commissioner.
Commissioner. This is one of the license condition.
Here's the level. So what is which license has been, you have 3 licenses. Which license has been,
Sir, we have applied for both all the 3 licenses, my lord.
huh?
We have applied for all the 3 licenses, my lord. All the 3 licenses we have applied for renewal, my lord.
Huh?
My lord, they have not processed it, my lord. They're saying that it cannot be renewed, my lord. Because of the order of the commissioner, my lord.
Cannot be considered at this stage. Where is the commissioner order?
Page 51, my lord.
Temporarily suspended. What is the injunction order?
The operating part, Lordship, find it page 49, my lord, the operating part. Para 44, my lord.
Come to page 33.
My lord.
Which one is your brand? Left or right?
Ragi, my lord, both are my brand, my lord.
Huh?
Both are my brand.
Both are your brand.
Dispute arise, my lord. I was using different label. I was using different label, my lord. Subsequently, I changed my label. They feel they agree with this labeling, my change of label.
Now come to, let us have
My lord.
an understanding. Come to page 34.
34, my lord. My lord.
So your dispute is with Rhino.
Rhino has filed
Huh?
a commercial suit.
Huh?
Rhino has filed a commercial suit. Yes.
Ha. Rhino. Page 44
My lord.
should say using, selling, soliciting, exporting, displaying, advertising, or any other mode or manner, dealing in, using the impugn label, trade dress, label, color combination, packaging of its product, ragi, or any other label, packaging which may be identical with or deceptively similar to the plaintiff's label, trade dress, label, color in relation to counterfeit. They are also restrained from doing any other act amounting to or likely to passing of or violation of prisoners' right in the said level used in the country spirit, infringement of prisoners' copyright, disposing of dealing with their assets, including warehouse, till disposal of the suit. Criminal proposal. Yes, what is your contention?
My lord, commercial court has not put any restriction for using the brand name Ragi. That the restriction imposed is that, my lord, I cannot use similar label. I can have different label, my lord, different trade dress, but I cannot use the same label trade dress, which are similar to one Rhino, my lord. But I can use the different labels using same brand name Ragi. They are not agree with the Ragi, my lord, brand name Ragi.
But page 44, many things have been restrained.
Yes, my lord. Yes, my lord.
And for introducing another one, you have to get approval.
That I will do, my lord. Once I get my license are renewed, my lord, I will get approval from this court that this license we are going to apply this level if they have any objection or not, my lord. Until unless we have a license, my lord, I cannot go for it.
But the license condition says otherwise. The license condition is clear. Page 25 says each bottle have to bear a label.
That
And-
is in respect of one license.
One license. This is in regard to
But
license.
Another license does not have that condition.
That doesn't have the condition.
But by one stroke, you have stop renewal of all the three.
Because here what happened, if he is in this matter, this
Because page 25, each bottle bears a level previously approved. Page 25. That clause you have shown
yes,
that each bottle bears a level
previously
previously approved by the excise commissioner. Commissioner has to approve it.
yes.
For that, he may have to make the application perhaps as 615, whatever. 615 level.
Label based on a maximum.
615 bottles shall be level. Distinct number, so and so, so and so. He has to make an application.
Before that, he has to have a license.
What I am saying that I am trying to understand. I am not understanding. Firstly, say by the agreement, he can have a bonded warehouse to construct and work a bonded warehouse, right?
Right.
And this is specifically for what purpose? Country liquor.
Minor.
Store only country spirits. Clause 2. Right. Country spirit. Thereafter, by the second license, he has been given a license to reduce ENA, for manufacture of country spirit. Right.
True.
Then for the third one,
So bottling of portable country spirit.
bottling of country spirits. Right.
Pre-license.
Huh?
Pre-license. 3 licenses are
Three
there.
licenses. One is for
Storing.
storage of country spirit. Then second is to manufacture. Third is to put it in the market
Yes.
in bottles.
Yes.
Right. 615. This particular 615. There comes 614. Let us understand. Establishment of duty paid country spirit wholesale warehouse. 614.
614, your lordship.
Right.
Yes.
I think this is one license.
This is the country spirit wholesale warehouse. Yes.
Right? One license.
One license.
Because I am not very accustomed to it.
5.
Say 614, sub-rule 3. On receipt of the application for license, the district collector shall examine the suitability of the site, building with regard to any other matter. They have to send the application along with his opinion to the excise commissioner. The excise commissioner shall thereafter, after such inquiry as he may think necessary, forward to the state government with his opinion in this regard. Then the state government shall consider the application and opinion of the excise commissioner may sanction the grant of license. After the state government has sanctioned the grant of license, the applicant shall be called upon to make arrangement for the construction of the warehouse. Then next, after the applicant has complied with the instruction as aforesaid, the excise commissioner shall approve the plans with such modification of the building, right? Then shall send the same to the district collector for grant of the license. Then Sub-rule 5. Before the license to a warehouse is granted, district collector shall pay, the applicant shall pay.
Prescribed security deposit.
Ah.
Equivalent to the- This is
Then when the then he can further obtain license for selling it in retail, sub-rule 7.
license. He can make that.
But when he wants to sell it in bottle with a brand, 615 will come.
615 comes in.
I'm trying to understand.
I'm trying to understand.
I'm also not very familiar with this. And where from this license, the second one, this ENA,
ENA,
where is the provision for that?
this might come 594.
594.
The validity of license shall that subclause to your lordship. The Excise Commissioner may subject to a state government grant a license the following description: license to establish private bonded warehouse or deposit or storage of extra neutral alcohol.
For the manufacture of county spirit.
Yes.
And for the deposit and
And
storage of manufactured county spirit. License for reduction of manufacturer license. So by this, he can manufacture country spirit.
Yes.
Right.
Yes. He has to have the ENA. From the ENA, he manufactures the country spirit.
The third question comes about the brand.
Brand.
First is warehouse for storage.
Storage.
Second is permission to
That's ENA.
ENA.
Yes.
Then
Thereafter,
third is
bottling and
after making country spirit, putting it in a brand in bottles.
yes.
Now, interference is the third one.
Third one. Interference is in the third one.
Is
Exactly.
the third one. How does it restrain the court order? Court order says the ragi
Yes.
and all. That has not stopped the petitioner from operating the warehouse and for EN and for making country spirit. But he has been restrained
In all the
from
three licenses.
putting the country spirit in the market in bottles under the brand name Ragi in a particular design and label and coloring and all. Right.
Right.
So if that is so, then how the three licenses can be stopped? Because commercial code has not stopped that. Commercial code has said, don't put this ragi in this kind of brand, put it in the market with this color combination, with this level. But so far as warehouse, when it is made, it is not the case that the country spirit has the same contents with Rhino. Alcohol content 5%. That is a prerogative of the how he makes it. Inside the things inside the bottle is not in dispute. Things outside the bottle is in dispute.
Color combination label.
Color combination label. So he can make country spirit. He can maintain the warehouse. But you have the subject matter in the page 58, renewal proposal of bottling of country spirit, reduction of ENA and bonded warehouse license. All three have been put to stop. But thing was made limited to Ragi and its
labeling
and maybe bottle size also.
No, my lord.
Bottle size, we say 750 perhaps, or 1 liter standard. You permit, I think, 750 ml
750.
or say half of the size. So that is the restriction. So it has to be 750 ml or 1 liter, whatever it may be. But how you have stopped it? Mr. Gogo, you explain your situation by filing an affidavit.
That will be better, Your Lordship, because
Mr.
most probably, in my understanding, all the three licenses might be interconnected, Your Lordship. Because
That
if you
is
want
what
to
now-
bottling, if you want to have to go for bottling for manufacturing,
Save or without bottling in a particular brand, after maintaining warehouse and after ENA permission, whether he can sell it in retail or not.
he cannot sell because he has no, because if he has a label, then he can sell. But if he has no label, he cannot sell. And for that, he has to apply that rule. My lord has pointed out this rules.
Yes, that's 614,
614.
sub-rule 7. Sub-rule 7.
Sub rule 7.
To sell it in retail, he has to have another permission.
Another permission. He has that permission. Doesn't have. We don't have. So only thing is that as per mine, this 3 license you store the ENA and the country spirit bottling. These 3 might be interconnected, Lord.
No, but renewal, how we can stop the license on the strength of the commercial court order. Ragi is okay, but that has stopped the whole business
Yes.
because he perhaps is at liberty to launch
A different one.
different men altogether also from scratch also,
Yes.
right? He is, I know, he is selling as I know, he can make an elephant also. Or with a complete different color combination, with a complete different style. Say he was selling in, say, red bottle, he can sell it in black bottle. Level
Completely
could be
different.
different. The effect of the commercial court's restraint order is because of the subsequent orders of the commissioner and the superintendent is catastrophic perhaps because he is in the verge of closing the business.
So at this point, let there be a provisional renewal sanction be granted to him, Your Lordship. Because in that way, his license survives. So in the meantime, he'll give us the commissioner apply for a new brand.
Even my brand is not disputed, my lord. Only color that I can apply.
No, that will not go into that.
My
When the commercial court is in season of the matter, why should we enter into that, Mr. Mishra?
Saying, my lord.
We don't know because it is an exhaustive order. Page 44, page para 44.
Yes, my lord.
We don't know what the court has interpreted, right? But it is clear. Page 44. Are restrained from using, selling, soliciting, exporting, displaying, advertising, or by any other mode or manner dealing or in or using the impugned label, trade dress, label color combination, packaging of his product, ragi, or any other label. So any other label is gone in packaging. Everything has been, which may be identical. That is a matter of dispute. That you may have to seek permission from the commercial court that I am thinking of launching this with this packet. You can seek modification or vacation of the order or clarification of the order.
Yes, ma'am, that I can see.
Right.
Ma'am, that I can
So we are not entering because any other level packaging.
I got a lot of point.
Right. For that you have to go there. But question is how it is interlinked. That is I am not.
Even the rules are not very clear about
Not
Your
very
Lordship.
clear, Mr.
It's better at this point of time, let the provisional sanction be granted to him. In this survives. In the meantime, we'll file an affidavit. That will be a option.
Suspension of your license. It cannot be. How does we pass the order? The order of the commissioner of so and so. Mr. Gogoi, if this has to be decided.
Yes, Your Lordship.
Your entire stock has been freezed.
My lord.
Along with the existing stock of level. And what is the present status of the commercial suit? Have you preferred any appeal against it?
Appeal was dismissed, now preferring the second revision, my lord.
Appeal has been dismissed. Temporary suspended and part of order. Actually, you could have executed the commercial court restraint order. You have proceeded further, perhaps.
Yes.
It looked
And-
like
Just went through the rules, rule 585, that whole, this country spirit.
maybe the commercial court, each product, this line, page 49, and or any other level. That is something which is more, with a condition, which may be identical with or deceptively similar to the plaintiff's level.
Hmm.
Mr. Mishra, I tried very hard, but I could not envisage how this is to be. Let them give the chance. By
It's better we file
20,
it.
you file the affidavit. We'll keep it in the motion stage. We'll consider on 22nd.
Very well, Lordship.
Right. In the event no affidavit is filed dealing with the matter, the interim order will be kept for consideration. Right, Mr. Mishra? I'm trying to,
My lord.
I tried my best, but I could not. How this is linked? Heard Mr. R.S. Mishra, learned counsel for the petitioner, and Mr. R.R. Gogoi, learned standing counsel, Excise Department, for the respondent number. For all respondents, first of all. The petitioner was granted 3 licenses under the provisions of the Assam Excise Rules, 2016. And the licenses are 1, page 16, license to construct and work a bonded warehouse for the deposit and storage of extra neutral alcohol, within bracket ENA, within the premises of a manufactory without payment of duty for manufacture of country spirit and for deposit and storage of manufactured country spirit. 2. Bottom to page 16A. 2. License for reduction of ENA for manufacture of country spirits. For the first 2, there is no requirement of any label.
No.
And 3, license for bottling of potable country spirit. First of. As per one of the conditions for granting the license for bottling of potable country spirit, each bottle is required to be at a level previously approved by the Excise Commissioner. Close to. Para. One. What is the name of the plaintiff?
Associated Alcohol and Beverages Company.
One Messrs. Associated. What is the name?
That your lordship will find that.
The name is itself. Where it is?
I have given in my synopsis, my lord.
Synopsis.
Yes, ma'am.
In the order is not there.
Lordship is there.
One Messrs. Associated Alcohol and Beverages Company has instituted a commercial suit commercial suit number 11 stroke 2025 alleging violation of rights in the level used by the petitioner along with Pusto by filing an application, Miss within bracket J case number 146 of 2025, the plaintiff had also sought for an ad interim injunction also by an order dated 12/11/2025, the learned court disposed of Miss J case number 146 of 2025. Most of the operative parts of the order read as under page 49 of paragraph 44. Para. On the subsequent to the order dated 12/11/2025, passed in Ms. J case number 146 of 2025 by the Court of Learned Civil Judge Gauhati. The respondent number 2 by an order by the impugn order dated 18/11/2025 passed as ordered for temporary suspension of the country spirit brand Ragi, registered by the petitioner under the aegis of AEGIS, Messrs. Brahmaputra Distillery, until further orders from the learned from the Court of Land Civil Judge, Gauhati. Sorry, post of. Where the plaintiff has instituted the commercial suit on the premise that it is in the business of blending and bottling a wide range of country spirit, IMFL and country spirit, such as Rhino number 1, Rhino, etc. Post. In the suit, the petitioner, so the plaintiff, has projected that subsequently, the petitioner, the defendants, that is the petitioner, started business of country spirits with a level ragi, the level of which LABEL is deceptively similar, having levels, having deceptively similar font and similar color of label to that of the plaintiff. Post of. After consideration, the order dated 12/11/2025 has been passed by the Civil Court. And the same said order is still in force. Post of para. Subsequent to the order dated 18/11/2025 of the respondent number 2, the respondent number 4, sorry, 5, has passed an order on 26/3/2026, whereby the proposals for renewal of the petitioner's aforesaid 3 licenses whereby the respondent 5 has observed that the renewal proposals of the petitioner's aforementioned 3 licenses cannot be considered at this stage. First of Mr. Mishra, learned counsel for the petitioner, has submitted that the restraint order passed by the commercial court is limited to ragi, limited to limited in manner as indicated in paragraph 44 of the order. So therefore, on the basis of the said order, the renewal proposals for the 3 licenses could not be kept in hold. As a result of non-consideration of the renewal proposals of the 3 licenses, the petitioner's business has virtually come to a halt. And full stop. Para. As the matter. Full stop. The respondent authorities are required to explain the source of power, the basis on which the impugn order dated 18/11/2025 and impugn order dated 26/3/2026 have been passed. Full stop. Which full stop. The orders are full stop, on the basis of the provisions of Assam Statutes 2016. Full stop. For a consideration of the intent prayer, comma, the respondents are required to file its response promptly. Full stop. Mr. Gogoi, in understanding also, Excise Department shall file the response on or before 20/04/2026. Post of this the case. The case is to be listed on 22nd of April 2026. The prayer for interim relief is kept open for consideration on the same date.
Please, item 8.
Item number 8.
There is no retention on behalf of the petition to them. Mr. S. Total and standing concept in the development department for the respondent half. One, two, 4, 5, 6. And K go good. Additional senior government for the respondent 4 are then. In view of non-representation, we have the petition to their council that this be listed again on so and so.
My lord, maintainability may be kept open, madam.
2404.
My lord, in fact,
Mr.
8, 10 and 19, same matter, madam, same petitioner.
Mr. Dr. has raised an issue of maintainability of the petition on the given facts and circumstances of the case.
10 and 19 is my matter.
You were there?
Yes.
Similar matter, my lord.
Non-payment of contextual.
Similar for, why you have raised the issue of maintainability?
Because, my lord, admittedly, from our, my lord, commissioner, my lord, it was not admitted.
Is it-
Although that was sent, my lord, yes.
Is there anything on record?
My lord, yes, my lord.
What is that? Where is it?
My lord, I'm just giving.
Item 10, phase 50, lordship may kindly.
The petition has preferred this petition seeking a direction. The respondent authority to release
Item 8.
two amounts,
82 case.
where page 22%.
Junior,
Release an amount of rupees 73,13,414. Claiming that the same amount has remained outstanding despite supply of materials. To the respondent authorities. by virtue of supply orders issued to him, first of Mr. Rafael and Standing Council Panchayat and Rural Development Department has submitted that as has raised the issue of making, the given facts and circumstances of the case. He has submitted that the yes, where is the draft?
My lord, page 58, my lord. In item 10, my lord.
No, I am into 8.
8 is also there, my lord.
Same petitioner.
Same petitioner.
Council is same or what?
Council is same.
Council
but
same.
Only one person's name shown, that's why I have not been able to test that matter.
Mr. J. Abbas.
Lordship.
J.
Lordship, may I kindly see the next page, Lordship, 59
50.
with.
In item 8, page 55.
55.
Yes.
56.
He has submitted that the supply of materials claimed by the petitioner fall in non-permissible category in under the MZ and REGA scheme, and therefore, the supply orders could not have been issued to the petition. So the matter would require consideration. You should notice returnable on so and so, as Mr. So and so has appeared accepted, no problem in case. Extra copy during 2 working days. The issue of maintainability of the retribution is
Lordship,
open of
one thing, Lordship.
for consideration at an appropriate stage.
One thing, Lordship, just one thing I want to point, Lordship, on the next page, there is a report, Lordship, regarding maintainability also, Lordship.
No, we are not
Lordship,
saying.
Lordship,
We are
yes.
not.
I'm deeply aware.
We'll examine, what is item number 10?
Item number 19 is.
8, 10, and 19, same.
Yeah, 81,095. 81,95,271.58. Parties are same, respondents.
Yes,
My lord.
S. Doctor 1, 2, 4, 5, 6. Here go with 3. Was it? 3. How would you assume?
In item 19, Lordship,
19.
In item 19, my lord, costly in the GNM may be reflected. In the costly GA Assam may be reflected, item 19, lordship.
70,000, 70 lakh, 8,000,
এখানে নাই দেখি
949. Synopsis.
Opinion ID 19.
The name of
Opinion again.
the learned government advocate, some be reflected in the response side in the call.
In 19, Lordship, item 19, Lordship, there is a typographical mistake on my part, Lordship, regarding.
Nowadays, everything.
I have to, they have to file.
Everything is I.
2505.
You mean extra political?
Item number 9.
Plus, Lordship.
Had Mr. Abjad Mazumdar learned counsel a petition. The petition is preferred. Challenging an amount dated 3/12/2025. Passed by the Learning Labor Court. In case number 02/2020. 3/12/2025 question. Issue notice returnable constraints. They have summoned the respondent by speed post. The records of so and so. Case number so and so be requisitioned.
Item 11.
May it please your lordship. Lordship, this is non-payment of
Heard
contractual.
Mr. S. Upadhyay.
Yes.
Learned counsel for the petition. Ye Gogoi. 1,
One,
3, 4,
Three to
Five.
seven, lordship.
6, 7.
Lordship.
R. Bobudari, standing of the finance 2. Close the hearing. Seeking a direction to the responding authorities to release an amount of rupees 23,18,780 as against supplies of materials, articles, goods on the basis of number of supply orders. The petitioner has preferred the instant liquidation. Issue notice returnable so and so as Gogoi and Borpujari. No formal notice, extra copies.
Deeply obliged.
2505.
Filed in. Reversing the claim of the petition on or before the returnable date.
Item 12.
May I please?
Yes, Mr.
Uh,
Hello?
Here in this case, my lord, the petitioner is aggrieved with the demand notice issued by the Employees Insurance Corporation, my lord.
Page 52.
Page 52, my lord.
Hmm.
And prior to this, my lord, your lordship, page 51, your lordship may kindly peruse. Where I-
Yes, page 52, come to page 52.
My lord,
Last line in bold.
in case you are not satisfied with the referred case, you may prefer appeal under section so and so appellate authority. Yes, my lord. That is there, but so far as why I am before your lordship, my lord. As per their order letter, my lord, I have submitted all the documents since I have been paying the contributions, my lord. And they have in their page 51, my lord, in their letter, they have asked me to submit all the documents and they will pass a speaking order.
When an appeal provision is there, why repetition is to be entertained? Why you have not preferred the appeal?
Yes.
It was 7/12/2025. You were aware about
Two
it was
months already, no, my lord, 2 months already over. In fact, petitioner is waiting for
Okay.
his speaking order.
Why you have waited after the order?
And he is
It is
received the
not
order.
that case. It is not that you are not aware of litigations. You understand.
Yes.
You approached earlier,
Yes, my lord.
right?
And
And
we
you
have,
preferred appeal also. And
Yes, sir, yes,
appeal was disposed of in your favor,
my lord,
right?
my lord.
Then you waited to
No, my lord, that,
for expiry of the appeal period to come to the High
no, my
Court.
lord, that is not my case, my
Then
lord.
it is
Since, my lord,
specific.
I have already.
Now, whether
submitted the-
after 45AA before the appellate authority, whether an appeal can be preferred under section 75.
So, that is there, my lord.
There, then
But my lord, I have submitted before all the documents.
why will go into that factual aspects, mister? You approached earlier. Court granted you liberty to file an appeal under section 75.
My lord,
You preferred the appeal,
my lord,
got the relief.
my lord.
Then again a dispute arose. Then you submitted your whatever details.
Petition, my lord.
They passed an order on the base judgment basis, right?
No, my lord, that does not, no, my lord. That is, in fact.
Mr. Shall I read? Shall I read? Shall I read the order?
For page 51, my lord.
Page 52.
I am pressing on 51, my lord. Since, my lord, I have already submitted.
When there is an appeal, why should we entertain? And that appeal opportunity has been missed by you. Knowing fully well.
No, in fact, my lord, that part.
When it was served. When it was served.
Because, my lord,
When this order has been served upon you.
my lord, I am residing at the Kacha district, my lord.
When it was served.
And I have received in the last part of February, my lord. He has received, my lord.
Good enough.
Then 60 days period.
60 days is there.
Lordship.
Where is your statement?
I have not stated.
Still 60 days is there.
Lordship.
Just you want to avoid that
No.
pre-deposit. Why should we entertain? And that amount is not onerous.
No.
You are a class 1 contractor.
No.
Not a regular. Not a regular, my lord.
Mr. Along,
My lord,
if it has been served upon you in February, we are in April.
Lordship.
Which date?
Within the period, Lordship.
my lord, in fact, my lord, he approached before this honorable court much earlier, my lord. In the month of March, my lord.
If 45A is not available, 75 is available.
Lordship.
So you have lordship, my lord.
Dismissed with cost.
No, with liberty.
Liberty we have approach from now.
With liberty to withdraw, my lord. To approve.
Don't try to bypass the statutory procedure. Once you have got the relief after the court directed you to approach the appellate forum, again you have come.
My lord, again, they have faulted, my lord, since I have
Mr.
been
Along
contributions.
has heard Mr. I Along and counsel for the petition and Mr. K. Gogoi Learned,
Lordship, I am for one, Lordship.
Central Government Council for the respondent number 1 post of in this petition, the petitioner's impugned has released an order dated 7/12/2025 passed by the passed under section 45A of the Employee State Insurance Act 1948 as amended first of. In the order itself, it is mentioned that the petitioner has the liberty, has the option of preferring an appeal under section 45AA of the ESI Act to the appellate authority within a period of 60 days from the date of the order after deposit of the statutory amount assessed or assessed to stop. Mr. Alam has submitted that the order dated 7/2025 has been served upon the petitioner in February 2025.
26.
And the period of 60 days has not yet expired.
Lordship.
Post of. As there is an adequate alternative statutory remedy, alternative and efficacious statutory remedy under section 45AA of the ESI Act. And the period, and it is found out that the period of 60 days has not yet expired. Mr. Alam and counsel for the petition has sought liberty to withdraw, leave to withdraw the petition in order to prefer the statutory appeal. Post of. In view of the above submission of Mr. Alam, the petition is allowed to be withdrawn with the liberty to file with liberty to the petitioner to file the statutory appeal.
Item 13.
My lord, may I please your lordship?
Yes.
My lord, permit me to address your lordship through the VC, my lord. My lord,
Yes.
this is a small petrol pump, my lord, under the KSK scheme, my lord, of IOCL. This is a Kisan Seva Kendra, my lord. Basically, they deal in high-speed diesel, my lord. They cater to the rural area and the agricultural sector mainly, my lord. So this
That I can find out, but question is that it is non-operative.
yes, my
For
lord.
how many years?
Since
my lord,
2011.
my lord,
Since 2011.
Since 2011.
yes, my lord, 2011 till date, my lord, but they also admit, my lord, because of the law and order situation, and the lesser's disturbance in the possession, my lord. So therefore, this was not operated. We came before your lordship, my lord, in 2022. Lordship has passed a detailed order, my lord, and therefore asked them if there is a change in situation, my lord, they can reconsider our recitement policy. So that was the order, my lord. And subsequent to that, my lord, we are constantly trying to revive this place, my lord. Now they issue, my lord, the show cause notice only in 2025. I will straight away take your lordship to the show cause notice, my lord. Lordship may kindly come to page number
79.
79. Yes, my lord. Now, my lord, I'm grateful, my lord. My lord, in 79, my lord, what they say, 780, my lord, they quote two provisions, 8 and 9 of the agreement, my lord. So, my lord, under these two provisions, my lord, they mentioned that minimum quantity was not sold at the station. So, therefore, my lord, we are in breach of clause 9. My lord, 8 and 9 presupposes there is a running outlet, my lord. Admittedly, my lord, they know throughout this period that matter has been litigated and there is a law and order situation for which this petrol pump was not operational, my lord. So instead of that, my lord, because if your lordship come to page 81, para 6, that's the specific provision, my lord. Why they're issuing this show cause. Para 6 lordship has. So, my lord, may I read, my lord? Para 6, the dealer has closed the RO without any authorization during the last 14 years. The facts enumerated above prima facie reflect that so-and-so is nil, selling for more than 14 years. And dealer and legal heirs is not coming forward and responding to any communication to revive the sale and therefore not inclined to continue the operations and functioning of the retail outlet. So therefore, the show cause on premise on two grounds. One, that there is nil selling, and second, Milord, there is no attempt to revive. Milord, I am on the second point, Milord, because the first point by their own admission cannot apply here because admittedly this was under a law and order situation. The lesser was troubling the possession. So therefore, Milord, after this show cause, Milord, kindly have next page 82.
A law and order situation that is self-defeating in a sense that I think you have heard that
Yes,
in
Milord.
the near vicinity of the retail outlet, two more outlets have come up.
Yes,
So that ground is, in the view of the court, is not.
Yes, Milord, at this stage, Milord, I'm not
How the
raising.
other two outlets can operate and your retail outlet is in non-operation for 14 years.
Yes, Milord. So therefore, Milord, now after this new show cause is
I
issued,
will issue
Milord,
notice at this stage, we will examine Mr. Vishwas.
My lord, may I kindly refer, my lord, because I have asked for a stay because otherwise they will evict me because the machineries, they will take over position of the machineries, my lord. Because why I am saying, my lord, because your lordship will see page 83.
Whether you have any machineries at all?
Yes, my lord, we have.
Where? Picture
Yes,
that
yes.
one.
I have annexed.
If anything says that they should be kept in good custody.
We cannot evict them. It is not our plot.
That is land that belongs to somebody else.
Somebody else.
My lord, the
We have
machinery.
dealt with the matter in the earlier round.
Yes, at page 7.
My lord, the machineries, I have annexed the machinery photographs.
Because I remember now, we have dealt with the issue
Yes,
on
my lord.
all four points.
Yes, Milord, but that was a different issue, Milord. Now, what they're saying, Milord, they're invoking 9 and they're saying since we are not maintaining, because kindly have the termination order, Milord. Kindly have that. At page 91, it starts. Kindly have page number 93. What is there? The termination, the basic termination order, Milord. Para 6, the second part of para 6, Milord. What they're saying, Milord. Therefore, prima facie, it appears that you have not kept the retail outlet dry in absolute breach of the aforesaid terms and conditions. You have also failed to honor the minimum monthly uplift products of so-and-so is violation of 8 and 9, my lord. My lord, here also, my lord, they are saying it's a prima facie breach in the final order. They are not addressing the main issue, my lord, that after the notice, there was a meeting, there was an undertaking given by them. They themselves extended the time. Kindly have that meeting, my lord, page number 85, para number B, my lord. Lordship has page 85.
Yes.
Last 4 lines, 5 lines, keeping this fact and background into consideration and the fact that the lease is valid till October 2027, one last opportunity for revival is accorded. They themselves accorded, my lord. So, my lord, what I do, immediately I approach the police and immediately I get an order because I have annexed that order, my lord. Kindly have page 90. Because the position was in dispute, the lesser was disputing my position. This is the order from the DM that against the lesser, my lord. May I read, my lord? This is order dated 17th of February. So I immediately approached the police, the DM, immediately after that order of 22nd, 24th, I approached. It was sent to the DM's, escalated to the DM's office, my lord. And therefore, the 17th of February, after, because it's a quasi-judicial process, my lord, hearing has to be given to the both sides. I get this order. I write to them, my lord, next page 91, that I am in possession. I'm sorry, not 91. 91 is a termination which I have shown, my lord. Page 94, that I have taken possession. I have annexed the photographs also, my lord. Page 96 onwards, that now there is a DM order. I am in possession. I have been placed under possession. I have taken these steps to improve that place. So please do not terminate. But still they go ahead, my lord, saying that they do not take all these factors into account, my lord. Now, neither the DM's letter, neither my letter that I am installing all this, I'm seeking permission to install a fresh underground tank, 2 dispensers. I annex that land filling is going on. Kindly see my letter, my lord, page 94. I have mentioned the land filling also is going on, my lord, there. So all these steps, my lord, are not taken into consideration in the 17th February order, my lord. That order clearly proceeds on the basis of clause 9, which says that I have not maintained the minimum minimum value of petroleum products, you know. So that is admittedly, you know, they also know that this is not running, not in running condition. That is an admitted fact. And therefore, in the 22nd of December minutes, they have given me time, extended time. You do all these things, revive it. And I'm taking all the steps, you know. That is page 9.
You should notice at this stage. No
Milord,
mention.
my prayer was, Milord, at least not the stay, Milord. They should not disturb the status quo, Milord, because those machineries and everything is there, Milord.
Yes, Mr. Borwa.
My lord, in this case, the order which has been highlighted of the district administration, my lord, will not be able to adjudicate on this issue in the absence of the parties, my lord. The district administration has not been made party, neither the DC nor the additional district magistrate. What proceedings have gone on? Further, there is no averment that this order was indeed communicated to the IOCL before the termination date. The representation is after the termination on 23rd of February. Then all this while they have been sitting idle. It is now April, my lord. And we have not taken any, in fact, the extraction of machineries, my lord, this is the property of the IOCL. These cannot be taken up all at once. If he makes out of a case that indeed the dispute is over, this can be easily restored back. But at this case, status quo ante cannot be granted, my lord. Notice may be issued. I'll answer all these questions.
And over all the property of the corporation. To the authorized the accounts. What about this page 93, last but one paragraph?
Page 93, my lord. Page 93, the last but one paragraph. To hand over all the equipment which are the properties, settle the accounts with 10 days of receipt of this letter, my lord. This is, till now, we have not taken anything. So we subject to the outcome, my lord, we make this subject to the outcome of the petition.
What is settle your accounts?
You know, there is a deposit from our end.
There is that. Maybe there are the deposits.
Deposit has remained since last 14 years.
14 years. Nobody has taken.
Therefore, my lord,
that is, and you are not operating the retail outlet for last 14 years.
Yes,
it is a fact.
It is a fact, Milord. That is
it is a fact in the earlier round also.
It is a fact, Milord. But I'm only on the...
Instead of keeping this in open, as reflected from page 96.
Yes, Milord.
In open under the sky, blue sky.
Yes.
Whether these machineries can be kept in safe custody of the IOCL.
Milord, if it is
if you succeed,
yes,
definitely all these are to be restored back.
Milord, that is, but Milord, these are underground tanks, Milord, because there is, because these petroleum products are, Milord, kept under the ground, Milord. These are extracted, taken away. Milord, most of this will be scrap material if it is taken out.
Okay.
Milord.
Petitioner undertakes to, if the petitioner undertakes to keep all the equipments in safe custody,
in his custody,
we'll keep it.
Milord, let them.
Now you will incur the cost. You will incur the cost.
Very well, Milord. Lordship may grant me a short date. I will.
Heard Mr. Vishwas, Learned Counsel for the petition through the virtual mode. Estate by Mr. You were there?
Yes, madam.
Estate by Mr.
Vida.
B. Das, Learned Counsel for the petition. And Mr. N. Borwa, learned it.
And for 2 and 3.
Also. Ms. B. Sharma, Central Government Council for the respondent number 1, and Mr. N. Borua, Learned Council for the respondent number 2, 3, and 4. Customer. Agreed by an order of termination dated 20/02/2026 within bracket annex 30. The petitioner has approached this court by the extended petition posted by the impugned termination order, comma, the respondent IOCL authorities have terminated the pet retail outlet dealership of the petitioner with immediate effect, and the petitioner has been called upon to hand over all the equipments, etc., installed at the retail outlet dealership of the petitioner to the respondent IOCL's authorized representative, and to settle the accounts in a period of 10 days from 20/02/2026. Post of the petitioner was served a show cause notice dated 21/11/2025. To show cause as to why the action contemplated therein, that is, action under the dealership agreement dated 12/3/2013, including termination of the retail outlet, should not be taken against the petitioner. Post of in the show cause notice, comma, reference has been made to clause number 8. Only clause number 8, clause number 8 and clause number 9 of the dealership agreement to praise that the conditions contained therein have been violated. Post of in response, the petitioner submitted a reply to the reply on 2/12/2025 to the show cause notice. Your show cause notice is hardly anything. Reply.
Reply is very short, Milord, but then there is a meeting, Milord, next page, 22nd of December. There was detailed, all grounds discussed. They acknowledge, Milord.
Which
para
one?
four.
Which one?
Page number 83, Milord.
That is personal hearing.
Personal hearing, Milord. There, everything is detailed. Para 4, last line, Milord.
So there's the comma. Personal hearing took place on 22/12/2025, wherein the petitioner has explained the position for non-operation of the retail outlet dealership and had undertaken to take all the steps for revival of the petrol or retail outlet dealership. Post of during the said meeting, comma, time was granted till 21/1/2026 for revival of the retail outlet dealership. Post of as the petitioner was taking all the steps, including an order on order to retain possession of the land on which the retail outlet has been installed on 17 to 2026. The respondent IOCL authorities had arbitrarily terminated the dealership by the impugn order dated 20/02/2026. Post of Para in response, Mr. Boro has submitted that the Petro retail outlet dealership had remained inactive for a long 14 years, and the said fact is discernible from the earlier round of litigation, which resulted earlier round of litigation, WPC number 2515/2022, which was disposed of on 21/6/2022. Post of. He has further submitted that the properties, sorry, the machinery is installed at the retail outlet are properties of the respondent IOC Corporation. Post of Para Mr. Vishwas Learned Counsel, but a petitioner has submitted that if the petitioner succeeds in this petition, we have submitted that there are underground, apart from, what is this? What does it say? Page 96, this second photograph,
1996, not.
page 96, what is this? What does it?
It
What
is
is this?
dispensing machine, Milord, dispensing machine.
Apart from the dispensing machine, there are underground tanks,
Yes, storage tanks.
storage tanks, which are installed by the petitioner. And if the same are taken away, the same would cause prejudice to the petitioner. One matter would require consideration, issue notice, rate and everyone so and so. As Mr. Ms. Sharma for 1 and Mr. Borwa for 2, 3, and 4, no formal notice. Extra coverage in 2 working days because of having regard to the fact that the dispensing machine, the underground storage tanks, and other allied machineries are installed at the cost at the retail outlet dealership at the cost of the petitioner. Though at the cost of the petitioner, though the same are properties, though some of them are properties of the IOC.
They are properties of the
All underground tank is not your property, perhaps.
construction. It is a tank. It cannot be taken out. It cannot be taken. It is not a
Though
property.
some of the properties are belong to the IOC Limited. It is ordered in the interim. The party shall maintain status quo with regard to those machineries till the return is late.
I'm so grateful.
1305.
Grateful.
Item 14.
Yes.
Petitioner Millard, the elderly lady is in a little bit of problem. It will kindly turn to the order at page 28. The disconnection notice based on
24/3.
page
Within 7 days.
27, no?
This is area bill, they are saying.
No, no area. Because our payment schedule, your lordship will see, we have just summarized the payment. Right up to March 26, the lady has paid the dues.
Amounting to so is pending against the petitioner, meter number so and so.
Online
Was
payment
clearly
history.
remain unpaid till date. Previously, that has disputed twice. This was in February. Page 26 is in February. Same amount.
Yes, we paid right up to October 25 to March 26. April, the date is going to come now. Otherwise, it is all paid, Millard. And it is, if your lordships kindly turn
No,
to.
after February, anything has been paid.
Yes,
No,
Millard.
why is this 61,000?
This is their calculation on the basis of their page 20, if your lordship see,
Page 20. Page 20. Yes.
rather below page 22 will be
22.
better. This is their bill, impugned bill of 61,000. Kindly see at the top below malpractice type, non-existing consumer theft of electricity. Have your lordship got it?
Yes.
Now, hearing date, they are saying
Non-existing
25,
consumer.
8, 10,
What does it mean, non-existing consumer theft of electricity?
Yes,
Yes, Mr. Das.
Yes, my lord. That is perhaps they have wrongly said that the theft of electricity, my lord.
Millard, at three places.
Like that only.
Well, if I may submit, my lord, I sought for the instructions, my lord. Upon inspection, it was found that my lord, the petitioners hearing, my lord, they have a 12 kilo load of sanction load, my lord. On that, my lord, on a residential connection, my lord, domestic connection, they are running a paying gas, my lord. So because of which the assessment bill has been served to them.
What?
Then there should be a commercial connection.
Notice.
No.
Yes, my lord, that instruction notice has already been
So
served to them. my lord.
instruction
I
may
have
be
my
there, but
instructions.
we are not informed.
Yes, now what is the demand notice?
Demand notice is below 61,000, 629 at
Okay.
page,
And
page
since the
22.
petitioner is a senior citizen
Yes.
and a widow of 75 years, don't disconnect the electricity and this demand notice shall remain suspended.
We have not disconnected as of-
until your explanation comes.
No, my lord,
Justifying your action.
no, what I'm saying, I have advised my respondent authorities, my lord, to withdraw the final assessment bill, my lord, because my lord, 120 under 126 procedure has to be followed there to have been from. My lord, what I have
Instruction tomorrow. We
I have my
can close this
instructions, my lord.
petition.
They have already, my lord, issued one more notice, my lord, to appear them before on 10th of submit the documents on 10th of April, and hearing will be conducted on
So
13th.
this demand notice.
This is not the way you can.
Give a proper notice.
Yes, my lord.
Notice, you have to give a self-assessment first.
That's what
Huh?
I'm hearing.
Page 27, your lordship will see this.
But this is a notice that which has already been served to them, my lord.
Yeah, it is there.
Though, my lord, these are not the proper way how they have served, my lord. That's why we have advised them to withdraw the final assessment.
Whole
my lord.
problem is, my lord,
This is to inform you that as per inspection report. Now, this story was never there.
Yes, no, my lord, the assessment, one notice that I have, my lord, that has already been served to them, my lord.
This is something which there is a procedure for
no.
going about things.
Good.
Mr. Das,
Yes, my lord. That's why my
this story now which you have projected,
Hmm.
it was never there in the demand notices.
Yes, my lord, it was not there, my lord. That's why we have asked to withdraw the, my lord,
You
assessment.
withdraw these all these demand notices, you can have the liberty of proceeding afresh with proper grounds.
Yes, my lord, they will serve, my lord. That's why we have asked, my lord, to withdraw the final assessment bill. Provision will be there and we'll serve the notice again to them, my lord. An
No,
opportunity
no,
to hear
let them
the.
file an affidavit, my lord, and say that we have withdrawn the notice.
Or you place instruction.
Huh.
Tomorrow.
This is not the way to deal with a consumer.
You can proceed, that is under the law. If you have the
No,
power.
Lordship may record my submissions, my lord. Lordship may record my submissions. I have my instructions to submit that.
No, no,
we will withdraw the
instructions
assessment.
will not do because you have your notice says at 22 non-existing consumer and you are accusing me of theft and your 3 notices.
That cannot be theft.
Man, that is not theft, man. That is
Maybe
unauthorized use of electricity.
Improper or use of electricity,
That is
or maybe that domestic has been used as commercial.
Yes, ma'am.
Those things you have to lay out in the
Yes,
notice.
provision for that.
Take your instruction,
And
right?
page 20, they don't.
You proceed with the matter afresh, then we can close this. No point harassing a
That is what I am
lady.
submitting, my lord. They will proceed with the fresh, my lord.
Tomorrow, get your instruction.
My lord, my
No, let them file an affidavit saying that they have withdrawn these 2 impaired notices.
we can do that.
Yeah.
If we can obtain written instruction, we can
So
close this.
the way they are functioning, I'm doubtful as to why they are proceeding against a lady like this.
My lord, this is
You
a
are
complete set of
saying that
instructions
there
I
is
have.
no meter, no
I already have my
meter number.
instruction.
At 3
No, no.
places of their
Thing is,
document.
my question is this only,
Yes, my
right?
lord.
You can proceed
Yes.
against the consumer.
My lord.
No doubt about it.
No,
Correct.
Right. The question is the story now you have projected may be correct. As in the indicated in the letter dated 7/4/2026.
Yes, yes.
Right. But those were not there.
Yes, that is correct, my lord.
Right.
Correct, correct.
There should be a clear indication that 12 kilowatt load was there. And you
Yes,
have
madam.
that was for the purpose of domestic connection. But we have seen that it has been used for purposes which fall in commercial category. There has to be clear
Yes, my
indication.
lord.
in the
That order
notice.
is not there, my lord. That is why we have asked to withdraw it and go for a fresh one, my lord.
Right.
That's my lord. That is my instruction.
You withdraw these demand notices.
Yes, yes,
That's what I'm saying.
They will
Let them
do it by today.
withdraw
I have
and
informed, my
tell
lord, they
your
will do it, my lord. They are on the process, my lord.
No, no, let them do it and tell you and file it before your lordship.
My lord, we
This
can
is
do it,
not
my
the
lord.
way to go about.
We'll do it, my lord. We'll file an affidavit if it's required. So.
If we issue notice, we'll stay this proceeding. That will be to your detriment. No recovery of the amount.
No, no, amount, how can they recover? We have been paying.
Right.
We are withdrawing it, my lord.
That is why I'm asking you to get a written instruction.
Yes, I will get the instructions, my lord.
That you are withdrawing. Then we'll record the statement in the order.
Yes,
and then we'll allow you to proceed afresh.
yes, my lord. I will take my written instructions, my lord.
Okay. Tomorrow.
And your lordship will stay the status, maintain the status.
As on today.
No problem.
Heard Mr. P.K. Goswami, Learned Senior Counsel, stated by Mr. B.P. Boral, Learned Counsel for the petitioner, and Mr. B. Das, Learned Standing Counsel, APDCL for the respondent number 125.
Yes, ma'am.
To stop. This one is by name. We're not issuing this. The petition agreed by service agreed by and a demand
28 million.
for an amount of rupees 61,629 by repeated demand notices, dated. By demand notices dated 21/2/2026
And 24.
24/3/2026.
Correct.
And allegedly inflated bill on the non-tenable ground, non-existing consumer threat of electricity. The petitioner has approached this court by the instant petition. First of Mr. Redas, land standing counsel, APDCL has submitted that he has received instructions in the matter partly, and he can complete his instructions by tomorrow. Close to raise the case tomorrow. Close to in the meantime, there shall not be any further action for recovery of the amount of rupees 61 lakh so and so, and disconnection of the electricity connection and the reference. Well, we can keep this, we can read.
Yes, my little lordship.
Get the instruction.
Yes, I'll take it in by tomorrow.
Daily list, item 15.
May I please your lordship? Lordship, the matter may be taken up tomorrow, your lordship.
There was a caveat from the railway side, my lord, but then there's some development, my lord, subsequent to filing of the case. I had challenged the 48 hours notice, but then the termination has in the meantime come, my lord. So I have not officially received a copy. So my remedy will be arbitration after all.
It has been received, my lord, by them on 4th.
My lord.
We have sent by registered post.
It was issued by post, so it arrived later. In the meantime, we filed a writ petition.
Oh. The arbitration is only the remedy now.
Okay, well, now, do you have anything?
My lord.
Hmm.
But
it
Mr.
is
B.
there, my
Pathak,
lord,
you
you can
are counsel
close.
for the petitioner. And Mr. H. Gupta, Learned Central Government Council for the response.
Oh.
NF
ठीक है
Railway Authority, full stop. Mr. Pathak has submitted that though the writ petition is preferred essaying a notice, which one?
The first.
A notice.
We had challenged 25/3/2026, which was 48 hours.
Page.
Page 175, my lord.
175.
175, Annexure 23.
Notice. "48 hours. Notice dated 25/3/2026. Giving 48 hours notice in terms of clause 62 of the standard general conditions of contract to commence work, an order of termination has been made in the meantime on 30/3/2026. First of Mr. Pathak has thus submitted that in view of the termination notice, the petitioner would have to seek appropriate remedy against the order of termination in such period of matter. This petition be closed in order to enable the petitioner to avail appropriate remedy under the law. Mr. Gupta, Land and Government Council. No objection to the above submission. In view of the above, the petition is closed for reserving the liberty to the petitioner to avail appropriate remedy as permissible under the law. They will discuss.
Item 16.
Let me. Look, this is a case where what will be for consideration of your lordships. I am a contractor. For certain aberrations on my part, whether that is outweighed by, for which I was already penalized, for which
I was already penalized. That is outweighed by further hostility and certain unwarranted action by the FCA, my lord. I think lordship will allow me to get through the sequence, my lord, for 5 minutes. Your lordship will not require 5 minutes, 1 minute late, so I know. My lord, I was appointed as a FCI transport contractor in May 2025 for a 2 years period for carrying foodstuff from a place called FCI siding at Archi Pathar complex, that is in Lakhimpur district.
Of which page? Or
My lord, page 44, 45. That order is admitted, my lord, for 2 years, competitive bidding.
Okay, appointment.
Archi Pathar complex, Lakhimpur district to Pasighat FSD. This is a 90-kilometer distance, my lord. Quoted rate is given, that was accepted. My lord, since commencement of the work, my lord, I faced certain problems, which were absolutely beyond my control and for no fault of mine. Number one, there were separate handling contractors, both at the receiving end and at the destination point. My duty is, my lord, after indent, my lord, I place requisite number of trucks at the receiving end, and those trucks are kept stranded for a whole day, at times even till midnight, at times even morning by the concerned handling contractors, laborers, my lord. I cannot reach beyond my control, my lord. For which, my lord, similarly at the destination point, when I place my loaded trucks, those are unloaded. Those are not unloaded by the, my lord, handlers of the laborers there. Rather, the laborers there who are working under a handling contractor, differently, separately appointed. And my lord, they are unloaded for the entire day and even till well past midnight on next morning. And as a result, I cannot send back the trucks to place in the morning at the receiving end the next morning, because a fleet of trucks I have to hire. Then, my lord, I can send back, had it been loaded for during the course of the, or even till late in the evening, but they are detained at times. Second Saturday and Sundays, my lord, trucks are not unloaded. These are essential commodities. No second Saturday, Sunday. Far below strength of my lord laborers deployed. I am only a transporter. Laborers are not in my hand. And no work done by the laborers on festive days, that is different thing. On various occasions, my lord, I brought this to the notice of the divisional authorities, even sent emails narrating my problems faced at both the ends. I have been doing FCI works, my lord, for last 10 years elsewhere. No problem, without blemish. This is, in fact, when FCI served a notice on me on 8/9/25 that my performance below, I replied back immediately within a week, explaining all these difficulties. Those are on records. I need not bother your lordship. Then the divisional manager, Response 4, held a meeting on 23/12/25 between himself, me, and a few other FCI officials. And I told them about my problems, and they appreciated it. And in a minute sort of prepared, and a conclusion was recorded, which your lordship will find at page 16, paragraph 12.
Page 16.
Page 16, it starts paragraph 12. That in fact a meeting was held between divisional manager FCI, district office North Lakhimpur, other officials of FCI and the applicant on 23/12/2025, last December, at FCI district office. After appreciating difficulties faced by applicant for placement and transportation under his, a conclusion was arrived at. The conclusion, my lord, quote unquote, Pasighat. Lordship may kindly, this was of 23rd December. Proprietor, me, was directed to provide 15 trucks in the next consignment, which will be escorted by FCI personnel from both DO, District Office, North Lakhimpur, and FSD Pasighat to identify the root cause of, my lord, road transport, and further assured allocation for the remaining days to achieve 100% capacity utilization. This took place. Once they escorted to see the ground realities of, my lord, loading and unloading problems faced by me, they escorted the vehicles via the way bridge What report they made, what findings they arrived at, my lord, that has never been communicated to me. Meanwhile, what happened? It was done. Meanwhile, on the contrary, FCI started deducting huge amounts from my monthly bills right up to, my lord, December, every month. Lordship, kindly have a look at page 55. Page 55 in the box, it is for the month of July, August. They deduct, my lord, they have already deducted liquidated damage and extra handling and total. Then again, your lordship, page 57, lordship will find a similar box. This was for September 2025. Liquidated damage is around 2,55,000, and then extra handling 45,000. So this way they went on to deduct till, my lord, December. I have stated in paragraph 17, already deducted. That way a penalty has been imposed on me. This is a penalty deducted. Now, my lord, I will draw your lordship's attention to two very interesting documents. Page 70. Thereafter, I improved. Page 70. This is their document, their communication. This is by the district office. January 21. Well, right hand side, lordship may note. Well, till December you deducted. Fine. January 21 from FCI district office to FCI FSD. Copy to me below. AGM movement. Read the letter. This is written to me. Sir, please refer to the trailing mail wherein it is informed that the current space utilization of FSD Pasighat destination point is approximately 91%, and there is no stake available for further induction of stock. In view of above, it is requested to kindly halt movement for 2 days so that the space becomes available for the induction, which clearly reflects the fact that I improved a lot, at least after December. Now again, come to the next document at page 72. It is of February, very recent. February 14. Again from the district office, copy given to me. Here the letter, kindly read. It is given to the divisional office movement. Please refer to the trailing mail wherein it is informed that there is no space available for induction of stocks at Pasighat. In view of above, it is requested to temporarily halt the movement, that means movement of goods to FSD Pasighat. This is for your kind information and necessary action, meaning thereby full transportation. And I was asked to halt transportation for indefinite period, my lord. For indefinite period. But despite all this, within a few days of this February notice, 9th of March, my lord, there issues the termination order in a most hostile manner, my lord, paragraph 74 to 79. These are all, I am reading, I need not read. They are quoting the terms and conditions of the model tender form, first page. These are all there. Second page, yes, contractor shall be liable for endeavor to transport, should do this, should do that. Page 30, next, 76, below. Whereas FCI Gauhati issued notice 8/10/25 to Mrs. Gretiston directing explanations, which I replied back, and penalty and deduction was made. Despite numerous communication, so-and-so order clauses deemed fit, resorting to termination and appointment of the contract at the risk of cost should not be initiated with a direction to finish reply to this within 7 days. In response, white so-and-so submitted my reply. This so-called was given, I am submitted. Then my lord reply is quoted 1, 2, 3, 4, 5. Next page, page 77, stating all these problems which I faced. Trucks have been fitted with liquidity, so labor strength is very low. Instance trucks loaded on 11/9, unloaded at 15/9. All these were my reply. Then next page, my lord, after discussing this below, there is no mention about the, my lord, the minutes of the conclusion of the December 23rd meeting, nor about the letters that the godown was full. I improved. Therefore, in exercise of the powers conferred under model tender from clause so and so, they have the power of termination. So and so for a period of 2 years is hereby terminated with immediate effect without prejudice to other rights and remedies. And forego security deposit, bank guarantee. Also, as per MTF clause 13, Messrs. So and so is hereby debarred for a period of 2 years from the date of issue of order without prejudice to other rights. The corporation will also take up for cancellation of the license. So it has not mentioned about FCI's own communication of as late as 21st January, February 26th, page number 70 and 72, whereby it was communicated, which clearly reflects that I improved. Yes, you deducted from June to December, you deducted. That was a penalty imposed. It is a double jeopardy. It is absolutely unwarranted, hostile, and arbitrary termination order, my lord. Therefore, page 17.8 and then 17.9, these are all copies. And then, my lord, in many such cases, I'll place here one of your lordship judgment also, which presently I am defending two judgments, in fact, defending in the writ appellate court and other single judge judgments and even divisional judgments. Such arbitrary, unwarranted, irrational orders by FCI court has been interfered under Article 226. But since, in this case, since the termination was passed after all a so-cause notice,
Where is the so-cause notice?
So-cause notice was, my lord, it has termination order, it has mentioned, my lord, page 50. They gave the so-cause.
Dated 8/9/2025.
Yes, my lord, they gave the so-cause, I replied. In the termination order also it is reflected that 8/9 so-cause, we so-caused and you replied on.
No, in page 78.
Lordship will find.
78, page 78.
Yes.
Second para.
Second para.
Final notice dated 12/1/2026.
Yeah.
Where is that?
That is not there. That is not there.
Oh, my lord, numerous notices were issued that your lordship will find at page 76, my lord. In the
Page
termination
76.
letter. Page 76.
Below, yes.
The middle part.
That I have already pointed out.
Which one? Which one?
Middle part,
Whereas, below.
whereas as informed, middle part, my lord, at page 76. Whereas as informed by FCI DO not Lakhimpur, the performance of so-and-so has been consistently unsatisfactory since commencement of the contract, despite issuance of multiple notices by the FCI not Lakhimpur from May 2025 to January 2026. That is by notices.
So every month they give a notice and they deducted the money. That I have already said.
So this is termination 1.
Yes.
Second is forfeiture.
Forfeiture they have done. All these notices per month.
And third is debarment. Where is the debarment notice?
Debarment is in the last page, my lord, last portion of the order.
No, so-cause.
Lordship.
Where is
Yes,
the so-cause?
page 78.
Where is the so-cause for debarment?
No.
My lord, page 50, my lord.
Page.
At page 51, therefore, last paragraph, therefore, by this notice, you are directed to explain reason for the continuous poor performance despite numerous communication and why appropriate action against your firm as per the MTF clause 11A, B, C, and other clauses deemed fit, resorting to termination and appointment of the contract at your risk and cost should not be initiated.
So that is
where is the debarment?
My lord, the debarment clause will contain under clause 11C, my lord.
MTF.
Where is that?
My lord, that agreement has not been annexed, can be.
No, there has to be a specific notice that you are going to be debarred
Yes.
and for a period of 2 years or whatever.
And like cancellation
If
of
my term-
license.
And that is another thing. That is
Can I
that is
submit-
not there within their purview.
Can I submit, man?
No, let him conclude.
just-
What happens?
Just that, well, I am coming to that. Therefore, the termination was passed absolutely, after all this, absolutely unwarranted. So in this case, since the notices were given, I went to the dispute redressal forum. Because in most of the cases, they raise these points.
It is there, last
Yes.
paragraph.
That there is a forum, you go there.
Huh.
Although this forum is manned by three FCI's own three own officials, no independent member. In earlier cases, your lordship overlooked that. Entered in 226 stateway. If the action is arbitrary, your lordship, a lot of cases, I am carrying two of your lordship judgment. Anyway, in this case, since there was a so-called notice, semblance of a notice, I went to the my lord deputy immediately after that, which your lordship would find at page 80. This time I went there.
Okay.
Because in all matters, they very often say, no, there is a provision, dispute redressal, go there. Kindly see page 80, I am reading, with a interim prayer. Order dated, this is the termination order. I have given it to Chief General Manager. Find enclosed application along with relevant annexures in respect of order and for providing opportunity of hearing before the redressal. Respectfully prayed that enclosed application may be placed before the aforesaid committee at the earliest, pending which it is prayed that committee may be pleased to stay and or withdraw the order of termination. Whether his contract has been terminated even after realization of losses. Next page is my lord page 81. Next page is the my lord formal my lord application before the grievance redressal committee. This was for file acknowledged my lord page 80 below on 16.3. They have acknowledged. I made an interim prayer. The authority which has a jurisdiction and authority to pass any order can also pass interim order. Till the time I am standing before your lordship, they have not invited me for any hearing. And therefore, I am before your lordship. Now, after my lord, this termination order, immediately in a peculiar manner, they issued two simultaneous NITs. One is at page 127. Page 127 is an ad hoc tender. This is for a period of 6 months.
On which date?
My lord, this tender was issued on 10/4. This tender was, or date is not given. Anyway, yes. They subsequently, my lord, they issued a corrigendum. I think after filing of this case, whereby the date of filing tender, last date is extended to 13th of April.
This ad hoc tender was issued when?
Yes, issued. And then kindly that has been extended. Then the next page, my lord, simultaneously they also issued a regular tender at my risk and cost at 133. This is very peculiar. Have a look at page 133. Online tenders are invited to bid, so and so, at the risk and cost of defaulter contract on me. Page 133.
Yes.
Short tender I have shown.
Was it, if termination is made, this risk and cost
Risk and
must be there?
Risk and cost, yeah.
Must be there in the contract agreement?
Yes, always. Suppose somebody puts in my place, after my termination is justifiable. And if someone works for the period at a price lower than me, the difference will have to be given. That is my risk and cost. That means risk and cost for claim. Now here, the last date for submission of tender is given, page 136. Box. Day after tomorrow. I mean, 10/4. the day after 10-4 in the box. 136. So therefore, at this stage, my lord, that should not be double jeopardy, double punishment. You have already penalized for the aberrations. I am challenging that. That is also in my cost title. But you have, and in January, February, you said the stocks are full. Stop. After when I improved transportation, when the godown was full, no space, you stop transportation for indefinite period. Then you issue this termination order followed by these two, my lord, tender notice. Therefore, my lord, my prayer will be, and I went to their grievance redressal. They have not till today, they have not given a notice to come for a hearing. I made a prayer for interim.
These are preceded by a number of notices,
All these notices were for, my lord,
multiple notices.
all for recovery every month. That this month you fell short.
Liquidated damages can be imposed.
Done.
Done.
They
That
are
is indicative of some indicative of the performance.
Yes, done. And for that, they have penalized me. Every month, my lord, I have shown July, August, September, October, November. They have penalized, they have recovered. They have recovered the money, curtailed from my bills.
That would not stop the employer for
No.
an
that's right.
action under
But the latest-
contract agreement.
But when I improve my position, then see, once they said 91%, then they say stop. So is it warranted? Double punishment. Is it warranted?
What is this page 117
117, my lord.
LD?
Yes.
Indent.
This is October. October shortfall. You have already penalized me.
October. November.
And I told about the difficulties handling contractors. No action has been taken.
So this is as per the terms of the contract.
Yes, they have.
This termination is as per the terms of the contract. I think if it is illegal termination, then it will be damage.
Damage already they have done. Then I.
No.
No, that's it.
In monetary terms.
So the question is, was it warranted after the February districts and developments of February? Till December, you have realized. At the very beginning, I submitted before your lordships that is it not too hostile, is it not unwarranted, is it not too arbitrary to have gone for to take recourse to this before improved persons and the godowns were full, and I was asked not to carry goods anymore because there is no space. In that background, in that situation, my lord, in that situation, we cannot impose both the penalties. You realize the money.
No, liquidated damages termination can also lead to the termination also. It is that the law is not that there is bar.
I understand.
The
That the situation warranted. That is the question.
so far out of these three MTF clause, termination with immediate effect and plus forfeiture of security and bank guarantee. Maybe it is as per the terms and conditions of the contract. So far as debarment, I don't know.
They have not.
That I don't know because there has to be notice specific in specific terms.
No, not giving any notice.
That, but you are not against debarment.
My lord, the question is, they have the power to realize liquidated damage. They have the power to terminate. But in the facts and circumstances and sequence and actions.
But come to page
Is it
125.
warranted? That is the point. Wait.
Come to page 125.
Yes.
These are factual things. Third
Yes.
paragraph.
Yes.
41% achievement. Persistent under performance.
No, I agree.
Third paragraph.
These are all notices for which they recovered, and the difficulties faced.
Yes, recovery of liquidated damage does not stop them from
That's right.
taking an action under termination.
Then about to my lord, see and verify my the ground realities and the difficulties faced by me. September, they escorted. A minutes was, minutes were prepared. September, they did it, officers accompanied. They appreciated my problem. That yes, if there is some problem in the handling, how can I be held responsibly? In spite of
This
that.
is slight difficulty, so far debarment is concerned, we can examine. This is harsh, very harsh.
What? Was it
Without any specific notice, meeting the two requirements that apart from termination, you are going to be debarred because it has many effects, adverse effects. But yes, Mr.
Yes. Only thing, Lordship will consider, was it necessary and warranted after December? Your own. Was it warranted? Don't be too hostile. Don't be vindictive. You said it's tough.
Termination is there.
Apparently, I am
that detail order has been passed.
And look at the dispute.
And consistent, they are alleging consistent, persistent underperformance.
And what the dispute redressal is doing?
Yes, I'm coming to it.
I
My
will-
preliminary objection is that the petitioner cannot have a two parallel proceeding at the same time, my lord, simultaneously, my lord. There is one coordinate bench judgment, my lord. Just two paragraphs I'm relying upon. It was a motion disposal, my lord. WPC number 5776 of 2024. Just last paragraph, last two paragraphs at page 12, my lord. Para 15.
Yes.
May I read it, my lord? On considering the above fact, this court is of prima facie view that there is no merit in the writ petition. However, in view of the fact that the petitioner has filed a representation before the grievance redressal committee in terms of clause 20 of the MTF for redressal of his grievance, this court is of the view that the present writ petition should not be entertained by any further by this court, as two parallel proceedings on the same issues cannot be allowed to be pursued by the petitioner. Para 16. Accordingly, this writ petition is dismissed, having said that as the alternate remedy have been availed by the petitioner, this court hopes and trusts that the dispute grievance redressal committee shall dispose of the petitioner representation petition dated 25/10/2024 at the earliest and preferably within a period of 2 weeks from the date of receipt of the certified copy of this order. The dispute redressal committee should not consider the observation or findings made by this honorable court to be the final observation or findings made by this court. They should also not be swayed by any findings and observations made by this court and should decide the petitioner's petitions on its own merits, my lord. So, my lord, this application has been filed on 16/3/20. Very recently, it has been filed, my lord. So, some time may be given to the GRC to dispose it of, my lord.
It is distinguishable. Why I am telling you, I have seen it. In a fast-moving scenario like this, will the appellate authority or the redressal forum keep on sitting over the appeal?
It's recently it has been filed, my lord.
That is a different thing. In a fast-moving situation like this, what is the duty of the grievance redressal forum? I imagine it's the authority which has the committee which has the jurisdiction and authority to redress the grievance has also the power, my lord, apparently, my lord, to pass an interim order. And that cannot. Today is what? Till today I have not been invited. They will keep on sitting. And this new contractor will come. My petition will become infructuous.
When did you prepare the?
On 16/3/2026, my lord.
This in this petition, similar submission was made.
Similar submission, my lord.
Similar submission was made. That
Page
same first tender notice. Then grievance redressal, paragraph 8. The same has not been taken up by the grievance redressal committee. So should be set aside. Similar submission.
Single yes.
Yes, I have to.
Yes.
Abide by similar submissions. More than 1 month elapsed at that point of time.
But that was for the final adjudication of the whole matter.
No, it is a motion disposal.
No. Final disposal of one grievance. He approached. But here, my lord, things cannot wait.
No, it is motion.
Motion disposal, my lord.
Motion disposal. So did he make any interim period before that given it is not
No,
clear?
if I make any comment on interim period, I don't think this has made out consistent performance, underperformance. Just because there is nothing on January and February,
Nothing,
no report.
nothing.
But
No,
so
my
far
lord, that
consistent
one is a-
non-performance is the ground. And detailed chart at page 117.
Had they, my lord, did it with a notice at the time when they
I think
recovered?
multiple notices.
My lord, so-called notice
No, no,
was
that's
issued
why
on
no.
8/9, my lord.
That I admit. But the
Multiple notices.
question
Consistent.
is from December I improved. And
Everything is as is, where is basis.
your
What to
official,
do?
your officials accompanied me and they saw the ground realities. I improved and I have shown the problems.
I can dispose of it, say, similar terms
My lord.
as the coordinate bench has held, or otherwise you can issue notice. But so far as the interim period is concerned, that is difficult.
That way, my lord, interim prayer to my lord, in a situation like this, you have seen.
That will be difficult.
So what will be my remedy now?
One is
About
grievance
the
redressal
termination.
committee, or otherwise final disposal. So far as the interim is concerned, this is not possible.
Let them pass before the last day immediately within the coming 3 days on my interim prayer.
Which one?
Grievance redressal form.
It will
They
take
can
a-
dispose of the matter within 15 days, my lord.
2 weeks, within 2 weeks.
Before then, my lord, before then, no follow-up to this tender, my lord. No follow-up to this tender, my lord.
No, my lord, it's a ad hoc
No, no,
was,
for the
let me submit it. Ad hoc has been issued to meet the contingencies, my lord.
No.
And subsequently, the regular tender has been
No,
issued.
that
for 2
public
years and
interest will prevail over
PDS
private
system will-
interest.
That's
So far,
fail, my
I'm quite clear about it,
Give them a shorter.
that if it is food PDS item,
My lord,
public interest must prevail over
No, definitely.
that. Ad hoc is an emergency measure.
No doubt about that. My lord, may I, sir? No, I'm not going against your lordship.
No,
But
yes.
I'm trying to assist your lordship. Let them pass the order, interim order or whatever order within a time, because this is, last date is 13/10.
Final
To
disposal,
a-
they will
No, no,
take
to-
for final disposal.
To a
Final
bit,
disposal.
yes, final lordship, your lordship.
That appeal should
To a
be
bit,
taken
it
up.
will take some time for finalization of tender. At least there should be prompt enough in redressing my problem within a period
Yes,
of
2 weeks. 2 weeks possible.
2 weeks.
Intra-party order, no condition that he should deposit a certified copy of this order.
Yeah.
It is an inter-party order.
Inter-party.
Interparty.
No point
No point.
that from the date of 15 days from the date of receipt of the order.
Slightly less, because before
Yes.
30th of April, to a bit, only last date is 13th of April.
My lord, he has failed, my-
Wait. There will be process after that to finalize and select a tender. Right?
So he have submitted a detailed appeal so that they can take up
Take up.
all the points.
So give the time limit within short time, 10 days, 3 officers.
2 weeks, 2 weeks. Election is there in between. Everybody is affected.
And then give me a liberty to come again.
Yes,
Yes, that is there.
that is
That's
always
fine.
there. Heard Mr. S.C. Borbora.
And against it, my lord, no opinion.
Yes.
Let them decide.
On merits.
No, see, if your lordship gives, write anything.
No, I'm not. Like the Korean bench order, I'll not observe any.
Fair enough.
I heard Mr. S.C. Borbora, senior counsel, estate by Miss, and the learned counsel for the petitioner, and Mr. P.K. Singh, learned standing counsel. FCI for all the respondents. First of all, para. Pursuant to the facts which are not in dispute can be narrated briefly at first of para. Pursuant to a notice inviting e-tender dated 24/12/2024. By a tender process was initiated for appointment on for appointment of a contractor on regular basis for a period of 2 years. Appointment of a transport contractor. Handling and transport contract.
No, I'm split
Okay, transport contract. Full stop. In the tender process, comma, the petitioner emerged as the successful bidder for the road transport contract ex FCI siding Archie Pothar complex to FSD Pasighat via Weybridge on regular basis for a period of 2 years, and a letter of appointment dated 17/5/2025 was issued to the petitioner. Full stop. On issuance of the letter of appointment, comma, the petitioner deposited the security deposit and the performance guarantee as required by the respondent FCI. Full stop. After completion of formalities, comma, the petitioner started operating as the road transport contractor. From FCI siding Archie Potter complex to FSD Pachigat via Weybridge. Full stop. But it is the case of the petitioner due to many hurdles received at the starting received at FCI siding Archie Potter complex as well as at the destination point at FSD Pachigat. The petitioner could not achieve the requisite degree of performance in the initial months. However, subsequently, the performance of the petitioner had improved. Full stop. During the interregnum, comma, a number of notices were issued to the petitioner from time to time, urging the petitioner to improve his performance. Full stop. However, after a final notice dated 12/1/2026, comma, the road transport contract has been terminated with immediate effect by an order dated 9/6/2023. Full stop. Apart from the order of termination, comma, the respondent FCI authorities have resorted to forfeiture of security deposit and bank guarantee. Full stop. In addition, comma, the petition has been debarred for a period of 2 years from 9/6/2023 without prejudice to any other rights that the respondent FCI might have under the contract and law. Full stop. According to the petitioner, comma, the respondent FCI authorities did not stop at the by the act of termination, as they have proceeded further to issue or to publish two tender notices. One for
Ad hoc.
ad hoc road transport contract for the same route, and the other for road transport contract on regular basis for unexpired period. Full stop. The petitioner is further aggrieved by the publication of the by the clause incorporated in the tender notices that the contract, the ad hoc road transport contract as well as the regular transport contract would be awarded to the successful bidder at the risk and cost of the petitioner. First of all, para, it is submitted by the senior counsel for the petitioner that though in terms of the impugned termination order dated 9/3/2026, the petitioner had approached the grievance redressal committee by filing an appeal
With the grounds stated therein.
On 16/3/2026. The appeal has not been disposed of till date, and the petitioner is facing the consequence of award of the two contracts at his risk and cost. First of all, in the appeal, the petitioner has also sought for an interim order to stay the impugned termination order dated 9/3/2026. First of all, if the senior counsel has submitted that if the either of the two contracts are awarded in the meantime, the prayer for suspension of the order of termination dated 9/3/2026 would become infructuous. Para, Mr. Singh, learned standing counsel, BTC, has submitted, in response, in a similar matter, a similar issue, similar issues have arisen in a writ petition, WPC number 5776/2024, wherein the road transport contract awarded to the petitioner therein was terminated apart from an order of debarment for a period of 2 years and forfeiture of security deposit, etc., in terms of the clauses in the model tender form. First of, the impugned termination order dated 19/10/2024 was challenged in the said writ petition. First of, the petitioner therein had also preferred an appeal before the grievance redressal committee on 25/10/2024 against the impugned termination order dated 19/10/2024. Post of a similar grievance was made in the writ petition on behalf of the petitioner therein that the grievance redressal committee had not acted in the right earnest to take up the appeal for consideration.
Not to pass any interim order.
Full stop. It was the Korean bench. Full stop. The said writ petition was not entertained by the Korean bench. However, certain observations were made in the order of disposal dated 8/11/2024, which are of relevance and which are of pertinence in the case in hand also. Post of para. Having gone through the order dated 8/11/2024 passed by the coordinate bench in WBC number 5776/2024. There appears to be no apparent dissimilarity with the case of the petitioner therein with the case of the petitioner herein. While the Korean bench, while not entertaining the writ petition on the given facts and circumstances of the said case, has observed that since an appeal filed by the petitioner before the grievance redressal committee in terms of clause XX, in terms of the MTF, for redressal of his grievance is pending, the same request to be the appeal request to be given due consideration by the grievance redressal committee. First of observing that two parallel proceedings on the same issues should not be allowed to be pursued by the petitioner, the writ petition was not entertained with a direction. No, on the ground that the petitioner has already availed the alternative remedy, and therefore before the grievance redressal committee, and therefore, the grievance redressal committee shall dispose of the said petitioner's appeal at the earliest. Full stop. Para. Since in view of the said decision of the court in bench, this court is also of the view that this writ petition, since entertaining the writ petition would amount to continuation of two parallel proceedings, this petition should not be entertained at this stage. Full stop. And therefore, the writ petition, since the appeal, since the petitioner had preferred an appeal against the impugned order of termination dated 9/2023, promptly.
Raising various grounds, my lord.
Promptly. On 16/3/2026, the said appeal is to be taken up by the grievance redressal committee in the right earnest for expeditious consideration, as the issues relating to award of the two contracts at the cost and risk of the petitioner is interlinked. Full stop. Therefore, this petition, it is therefore directed that the grievance redressal committee shall take up the appeal filed in the appeal, comma, the petitioner is seen to have taken a number of grounds which requires consideration on merits. First of, therefore, it is directed that the grievance redressal committee shall take up the appeal filed by the petitioner on 16/3/2023
And dispose
for
of.
its expeditious consideration. Full stop. And to dispose of the appeal by way of a speaking order
2 weeks from today.
within a period of, let us fix it then. 2 weeks, Mr. Singh, you tell me.
Today is 7th, my lord.
Ah.
Now, by 19th of April.
Within a period of 2 weeks, as expeditious as
No,
possible.
19 is
Mr.
Saturday, my lord.
Singh-
By 24th of April. my
Mr.
lord.
Singh, Land Standing Office, FCI has submitted that the appeal, a period till 24th of April, 2026 will be sufficient and reasonable for the grievance redressal committee to dispose of the appeal. First of all, he has further submitted that in the event, then he can finally dispose of,
Yes,
or
finally
you can
dispose of.
consider the
In-
interim prayer.
My lordship may keep both options open. Both options. It is
Either interim order or final disposal.
He has further submitted that in
That submission may not be from
No.
my mouth, my lord. Let it be.
okay.
from your
Okay,
lordship.
dispose of.
Yes, my lord.
From your lordship.
Then dispose of.
Dispose of, if they cannot, my lord, then it will be open for them to pass interim order.
Upon consideration of the grounds raised, all the grounds raised by the petitioner in the appeal on its own merits. First of, any order passed, the order to be passed by the grievance redressal committee should immediately be communicated to the petitioner in its recorded email.
And it will be open for them to pass interim order also. Give them that handle.
My lord, it would also
no,
be
that-
better to appear in person or in personal
Why
hearing.
all this? Just for
Other-
putting. Let me make
No, I
clear.
want to expedite for your client.
If the petitioner wants to appeal and approach in the personal hearing, the same can be intimated to the grievance redressal committee within a period of 7 days from today. If you want.
And that interim, sometimes it happens, my lord, from my experience, that it they start taking hearing, cannot be finished. So the interim, that handle should be given to them. It's their jurisdiction, only that much.
Okay.
They may or may not pass. Give them the liberty.
If for any reasons beyond it, which the grievance redressal committee is not able to dispose of in the appeal.
Before 23rd of April.
24th of April 2026, then the grievance redressal committee shall give its consideration on the interim prayer made by the petitioner without fail.
Yes. Obliged, my lord.
So against any order,
If the petitioner, if by the order to be passed by the order to be passed by the grievance
Any order.
if the petitioner, if after the order, if any order is no after the order passed by the grievance redressal committee, the petitioner feels aggrieved.
liberty is given.
The liberty stands reserved to the petitioner to avail appropriate remedy as admissible under the law.
Obliged, my lord.
Dispose of.
Dispose.
Item 17.
To devote the above observations and directions, the requisition is disposed of. Yes.
Your lordship.
But I am a proprietorial concern and I want to participate in the tender process. They only want companies to participate. I put a representation and the reply is
If I die, what happens to them?
Reply, yes, reply.
The reply is the one is referring to page 68, if lordship.
You have indicated to me.
Page 68.
Hmm.
That's the reply on the right, if I may read, madam.
We don't know, we can examine, you can submit your bid with this, you examine.
I may submit the bid, they may not reject on discount because it is not only arbitrary, it is against law. There's a law on that.
Should not stall the process. Yes, Mr. You were there
Yes.
for a tendering authority.
Yes.
So you are averse to proprietorship firm.
Proprietorship, because I have taken the instructions, there are past instances where, my lord, this kind of high-end products were sought to be procured.
For
and then-
everything, there are past instances. For everything, there are past instances. One can cite person, but is it in conformity with Article 1419?
On facts, my lord, that is not an absolute bar, my lord. Of course,
Whether
I
it
consider
can pass the test under 14 and 19.
14 and 19, my lord, it depends on.
Is it not? A company may have 2 members with 1 lakh net worth. A person can have 100 crores. So
Absolutely, but here is a
it
case.
cannot be the
Here-
yardstick.
No, my lord, lordship will kindly perceive a situation. This is this high-end, my lord, electronic product.
How much is the value, total worth?
Total work value, my lord, it is. It is not about.
There is nothing. Is there anything? That
No.
contract value is 2,000 crore.
No.
Huh?
But even if so,
How much?
the reason is
50 computers.
if I die, what happens?
Uh,
That is the reason. They will not go beyond that.
What this is supply. Either it would be they would fail or they would succeed. 50 computers, say for example, out of many, after 25 supply, he died. Who has to pay? It is you who have to pay. It is a supply. It is not that oil or something like refinery is being built up.
True. But these products are to be
Printer, inkjet printer.
inkjet printer, then, my lord, high-end tablets left, my lord. Because now the lordship will kindly see, my lord.
Tablet computer.
These items are sought
No,
to be.
are you going to pay him in advance?
No.
Then see the reasoning. What is the reasoning? Page 68.
68.
The company survives even after death, insolvency, or retirement.
Because
of-
where,
No, I am
no,
trying to
warranty-
understand the reasoning. Say 50 computers are to be supplied. Right. The man died
Yes.
before supplying.
Yes.
What will be the effect? The security deposit performance guarantee will be forfeited. Because failure. After 25 supply of 25 computers,
Yes.
he died. So you would not receive 25 remaining 25 computers. But for 25 computers, you have already received. It is only service, after sale service, where you suffer.
Yes. Basically,
Right?
basically that is
Then
right.
you don't release that money for 25 computers. Because after supply only,
No,
after supply only, you will release the money, full supply.
after full supply, money will be released.
Let us see the supplies, what
Yes.
items you need.
Yes. Lordship will kindly see, my lord, from page 19 onwards. From page 19 onwards.
Let us see one by one.
Yes, my lord.
What?
Page 19.
Processor.
Yes.
Processor. Intel Core. That is one. Next is computer printer.
No, high-end laptop notebook 10 pieces.
If Lordship is taking up page 19, Lordship will find in the
This
middle
is
portion.
supply.
Yes, supply.
This is not construction of a data center.
No, supply, because these will be required for my lord, by
So are you
disaster management
considering
office,
his submission of
carrying
these?
out, my lord, supervision.
Are you allowing submission of his bid provisionally?
Yes, that is, my lord, I was about to make a submission. These bids are to be submitted in the GEM portal. That is always open to him. Only because of the fact that there is a clause which only allows, my lord, limited companies to participate, does not ipso facto divide him to make, my lord, submit. Instead of submitting the bid documents, what the petitioner did, my lord, he made a representation. And in the representation at page 62, Lordship will kindly see the tenor of the representation. Lordship will kindly see the tenor of the representation at page 62. My lord, he is not only aggrieved by the ouster clause, he is also aggrieved by, my lord, the specifications. And he is
No, he has
requesting
come
changes.
here. We are only considering his submission in this petition only with regard to page 68. Nothing else.
Yes.
No other conditions.
Yes, and he can submit.
Huh.
He can submit.
And I will also observe privacy. Heard.
He can submit. And after evaluation,
So-
my lord, if he is aggrieved, he will have his immediate, my lord.
The rejection may not be on discount.
No, no, that we
No, no, that is, that I will not observe.
Then,
this
my
thing.
lord, I will oppose.
I would just place
Then
one.
take an observation that primarily it is not in conformity to Article 14 and 19. But method would require consideration, but why I cannot stall the tender process also. Let them thereafter dismiss your technical bit. Then we'll take care.
I am.
Heard. Because this ground is the ground.
This is only.
I will also try to do, my lord.
Definitely. Both are open.
No, there are judgments on this.
You have the right to reject his technical bid. He has the right to challenge again.
No, my lord, if lordship takes a prima facie view that
Primacy is not tentative. Primacy is not final.
my lord,
Shall I interpret again the word primacy? Heard Mr. S. Boniclan, Council for the petition. And Mr. R. Borpuzari, Leonard, standing
my lord, and standing council revenue, my lord, for all the three respondents.
Revenue Department for all the three respondents, for all the respondents. Poster. Who is the tendering authority?
Tendering authority, my lord, is the State Disaster Management Authority.
By a
Assam State
bid
Disaster
document.
Management Authority.
Bid document dated 13/3/2024, comma. The respondent number 3 has invited bids online for the following items. Base 51, item category গোটেই কেইটা লিখা আছে। The petition, which is a proprietorship firm having has claimed that it has experience of supplying the items mentioned in the bid document. However, the petitioner is agreed by a clause in the bid document which has restricted participation of a proprietary firm within bracket sole proprietorship. Post of when the petitioner made a representation stroke in the at the time of as pre-bid query seeking modification of the said restrictive clause, the tendering authority has made a reply to the effect that a proprietary firm, sole proprietorship, would carry significant risk, significant risk and in the event the proprietor dies, stroke such the business, then the business continuity would be under risk. Full stop. And the government and the procurement with large equipment and longer warranty of 5 years would suffer. Full stop. The reasoning. A reasoning is given to the effect that a company survives even after the death, insolvency or retirement of its member, but a proprietary firm, sole proprietorship, not survive after death. Full stop. The matter would require further consideration. Issue notice returnable on so and so as Mr. Borbujari has appeared and accepted notice on behalf of all the respondents. Formal notice dispensed with extra copies within 2 working days. Had the learned counsel for the parties on the interim prayer. Full stop. The last date of submission as per the bid document, the last date of submission of bid
13th of April.
13
April.
April 2025. Full stop. The petitioner has claimed that save and accept the alleged restrictive clause debarring a proprietorship firm to submit the bids in response to the bid document. The petitioner has met all the other eligibility criteria. Full stop. Privacy, the restrictive clause in the form of the clause whereby a restriction has been put for a proprietary firm, like a sole proprietorship, to participate in the bid requires an examination. What are principles embedded in Article 14 and 19, Article 19 1G of the Constitution? Also, if the petitioner as the participation in the bid document is in the GEM portal, the petitioner may proceed to submit its bid online in response to the bid document. Full stop. The tendering authority may. What is the date of technical?
That lordship will find at page 15, my lord.
April 15:30 hours.
May
13th
proceed.
April, my
May
lord.
proceed. May proceed to evaluate the bids received in response to the bid document as per the terms and conditions of the bid document.
They will upload it in the GEM portal, my lord. The time is, my lord, maximum time is, my lord, 3 p.m. on 13/4.
Okay.
The lordship will kindly 3 p.m.
3 p.m.
No, if he fails, fails.
Yes.
Oh, I'm not giving him relaxation to submit the bid After 13-4.
No, my lord, 13-4 till 3 p.m.
Ah.
Till 3 p.m. And 3:30 the beach will be open.
As per the bid document, I have said, as per the bid document, you open. Then you reject.
That is different, my lord.
Thereafter, we'll examine.
They will upload
point.
Thereafter, we'll examine.
It's not even open after 3.
And it is also open for you to issue a corrigendum prior to 13-4 also.
1305.
But we'll examine.
Absolutely.
It may end is in favor or end in your
What
favor. I don't know.
What I have gathered.
I am not come across, I am not read this kind of clause or this kind of challenge in any decision. So this is open for examination.
Absolutely. Ultimately, it's a doctrine of level playing field. my
That
lord.
is why I
am going to.
has to test it
Yes,
Article
yes.
14 and 19.
Yes, absolutely, man.
Grateful.
I'm so obliged.
And it is not a construction of a data center or what do you call nowadays AI, something like AI that man dies, everything goes. It
depends on the
a
facts,
supply of a computer. Yes, next.
Item 18.
This is regarding contractor bill non-payment.
All right, Mr. D. Gogoi, Learned Counsel for the petition, and Mr. M. Goyal, Learned Counsel on behalf of Mr.
B. Gogoi, Lordship.
D. Gogoi, Learned Additional Advocate General, Assam, for all the respondents. The petition has stated that against execution of contract works, the petitioner submitted his bills for an amount of rupees 44 lakh 30,287 close up, as the said bill amount has not been released till date despite repeated approaches and representations. The petitioner has approached this court stating that the petitioner has approached this court seeking a direction to the respondent authorities to release the said amount. Post of issue notice returnable on so and so as Mr. Bina. Returnable so and so as Mr. Bina. No formal notice, extra copies, 2 working days.
2505. Lodge. Item number 20.
Had Mr. D. Dole and Mr. N. Upaidhar and Mr. M. Setia, Learned Counsel on behalf of Mr. N. Upaidhar, Learned Standing Counsel, Irrigation Department. First of the petitioner stated that the petitioner had executed. Okay, N. Upaidhar. All respondents had executed. It was awarded 3 contract works. Wide synopsis. The petitioner stated that he had successfully executed all the 3 contract works and submitted a final bill amount of rupees 76,566. So substating that despite repeated approaches and representations, the said amount has not been released till date. The petitioner has approached this court by the instant requisition seeking a direction to respondent authority to release the said amount in his favor. Issue notice returnable on so and so. Same Upaidhar, all respondents, extra copies, no formal notice.
2505. Item 21.
Please.
Yes, Mr. Khan.
Herein
D. Botar, 1997.
1997.
Will dispose of?
Yes.
No. Yes, Ms. Kotoke.
Lordship.
Heard Mr. A. M. Khan, Learned Counsel for the petition. Who is for 1? Okay. Mr. K. Goel, Learned Settlement Counsel for the respondent number 1. Ms. S. Kotoke, Learned Standing Counsel, Election Commission of India. For the respondent number 2?
Lordship. Just 2, your lordship.
2. Miss?
Ms. Rajpa for respondent number 4 and 7.
4 and 7. Who is 4 and
10.
on behalf of Mr. J. Payang and H. Rajpal, Learned Counsel on behalf of Mr. J. Payang, Learned Standing Counsel, Home, FT, NRC. For the respondent number 3 and 7. And Mr. M. Sethi. Okay, 4 and 7. And Mr. M. Setia, landed junior grammar advocate for the response number 4 and 3 and 5. Who represents 6?
6.
6?
Yes.
6. Okay. The petitioner has stated that the names of his parents have been enrolled in the electoral rolls pertaining to published for 50 number of Propeta Legislative Assembly constituency. In the published in the years 1970 and 1985, 1989, right?
Yes. But in 1966 also his father died.
Oh, okay, 1966. Post of. In all the electoral rolls, the address of the parents of the petitioner was shown at village Belor Toli, post office Borghol, police station Barpeta, district Barpeta, Assam. In some of the petitioners claim that in some of the electoral rolls, the anything the brothers, the names of his brother and brothers or brother?
Brothers, your lordship.
Ah.
Fathers also, your lordship.
The names of his brothers are also included in subsequent, in few or in some of the subsequent electoral rolls published in 1989, 1997, and 2010, 2015. The names of his brother have also been enrolled along with his parents. Post of. Though the name of the petitioner was included in the electoral roll of 1997, as well as in the subsequent electoral rolls. The D voter mark has been put against his name. Post of. Recent one also.
Yes.
Huh?
Yes.
Which year?
2025.
Has been made in the electoral roll of 1997. Post stop. In the subsequent electoral rolls also, and also in the recent electoral roll of 2025. The same position has subsisted. By paragraph 3. Which superintendent of police?
7th.
District? Borpeta.
Yes.
LAC same?
Same LS.
Same as. Okay, let's follow.
Obliged.
Item 22.
Yes.
Yes, Lordship. 22 Paras Lordship has passed an order on 1-4, Lordship.
Yes, your lordship.
In same line, Lordship. it was-
One is to dispose of the.
Dispose of.
Dispose of Lords. It is,
Dispose of, already dispose of.
No,
Oh,
date,
in a similar case, your lordship.
this Chiranjeevi Karkil or 80,
okay. Let us see.
on similar line,
Yes,
Lordship, dispose of.
Earlier repetition was disposed of.
Yes, Lordship.
Which page?
There is no time limit, Lordship.
Which page?
Page, Lordship. Page 61, Lordship.
63.
60.
61, Lordship.
61 is the.
Okay.
Honorable court's order.
Tell me the respond numbers. R. Sharma, Oku, and Upadhyay, Technical of Irrigation. 1, 3, 4.
I am for Lordship.
1, 3, 4, 5.
1, 3, 4, 5.
RM
3 is for
same.
2.
I got it's the same.
Lordship.
Then what is the earlier repetition number?
Lordship, 1872/26.
No. 4, 7,
Oh,
4.
sorry, Lordship. It was 61 page number.
4749.
4749.
What is the amount?
Amount in this present case is
4 lakh.
4,31,909.
909.
Lordship.
Came up for consideration on same. When did you submit the representation?
11/9/25.
Same date.
Send.
Response number 4.
So, yes, it's one of them.
No change. Same.
Same, sir. There is no doubt.
Same.
All right.
Yes, Mr. Dekka.
My lord, I am a distributor of LPG gas cylinders, my lord. My lord, at page 24, annexure A. On 13/2/2025, a letter cum so-cause notice was issued to me in respect of alleging that ERV slips, equipment return vouchers, my lord.
Equipment return
vouchers, ERV, not first line, lordship will find. At page 24,
24.
as you are aware, while returning
ERV.
should be jointly signed by the representatives of
Just
the
a minute. ERV means
equipment return voucher.
equipment
Yes, madam. The cylinder, my lord. Cylinder and regulators, my lord.
return voucher.
Yes.
Document should be jointly signed by the representative of distributor and transporter.
Yes, my lord.
Distributor means you
I am the distributor.
and transporter is driver.
Driver, my lord.
What
happened, my lord? The bottling plant supplied cylinders to us, my lord. And among those cylinders, some are defective cylinders are there, my lord. What we have to do is we have to return the defective cylinders to them by signing the ERV slips, my lord. And that has to be signed by me and the transporter or the driver, my lord. And for that, my lord, the amount for that defective cylinders, they have deposited an amount against those cylinders in my PAD account, PAD account, my lord, PAD account.
PAD.
PAD, my lord.
What is PAD account means something technical.
Account,
Some technical thing.
account, my lord.
Oh, maybe. Okay.
PAD account.
PAD account. PAD account.
For that?
That is for sole purpose as a distributor.
Yes, but
Transaction with the IOC. Transaction with the IOC is to be in the PAD account.
pre-authorized debit account, PAD.
Okay. PAD, pre-authorized. These are technical terms.
Technical terms, my lord.
Pre-authorized. Pre-authorized?
Debit account.
Okay.
My lord, thereafter, my lord, an amount was deposited to my account, a bad account. Thereafter, my lord, a review was conducted by them, my lord, by the IOCL. In respect of the market return cylinders for the year 23 and 24. Thereafter, my lord, what they have found that the amount of rupees 32,54,218.58 is wrongly debited, wrongly credited to my paid account. Therefore, my lord, I was called for an explanation and was directed to file it within a period of 7 days. And if they find that my explanation is unsatisfactory, then they will deduct, my lord, find it page 24 in the last paragraph. May I read, my lord? In view of the above, you are hereby requested to submit your explanation with proof documents within 7 days on as to why the above cited debit deductions should not be raised against you. In case you fail to submit your explanation within the stipulated period or your explanation is not found satisfactory, 50% of distributor's margin received in the previous fortnight or rupees 50,000, whichever is higher, will be deducted in the first instance. Thereafter, recovery will be made every fortnight amounting to 50% of your distributor's margin earned in the previous fortnight or rupees 50,000, whichever is higher, till the total recovery is completed. If the pending recovery amount is less than rupees 50,000, then the whole amount will be deducted in one go. Thereafter, my lord, I filed a representation before the authorities seeking for extension of time. That lordship will find at page 25. I prayed for 30 days time, my lord. No response was forthcoming, my lord. At page 26, on 10/6/2025, at 5:11 p.m., I received a mail and the petitioner was instructed to appear for a hearing on 11/6/2025. On the said date, my lord, there was bereavement in my family. So on the same day, I replied to the email praying for another 7 to 15 to 20 days at page 28. And the matter remained thus, my lord, they have not taken any action, my lord. We are continuing to operate our distributorship. Then suddenly on, my lord, 10/3/2026 at page 30, without any further communication, they have deducted an amount of rupees, my lord, 2,84,744. And this is in respect of my lord will find it first paragraph, first column. 2,84,744, page 30, my lord.
Okay.
And it was deducted in respect of recovery of excess market return.
Okay.
That so-called notice, my lord. It was without any communication, and their intention was to give us a hearing. And without that hearing, my lord, they have deducted this amount. That first amount, my lord, the fortnight amount, my lord. My lord, in similar circumstances, my lord, similarly placed distributors, the same notices were issued. And they approached this honorable court on earlier occasion, my lord. At page 31, Srimati, one similarly placed distributor approached this honorable court by a writ petition 1804 of 2025.
Page 30.
Page 31. Annexure F. And the relevant portion, lordship will find it page 34. This writ petition was disposed of with a liberty to the petitioner to approach the authority, my lord. Page 34, paragraph 6. Paragraph 6, may I read it?
Oh, yes.
Considering the submissions made by the learned counsel for the parties, this court proposes to dispose of this writ petition, directing the respondents to grant an extension of 30 days with effect from today to the petitioners for making their replies to the communications made to them. The petitioners shall file their individual replies before the concerned authorities within the said extended period. The respondent authorities may also supply any documents that the petitioner may ask for to enable them to submit their respective replies. Those were the ERB slips, my lord, the relevant documents. Paragraph 7. Till the reply is filed within the stipulated period of 30 days, with effect from today, and a decision is taken by the concerned authorities, is made clear that there shall be no debit deduction of the amount specified in the communications dated 20/2/2025. Though all those are like this, my lord, are so-called notices. While considering the reply made by the petitioners, the respondents are at liberty to give a personal hearing to the petitioners. It is further directed that the recovery notice shall not be given effect to till the respondents take a decision on the replies made by the.
So are you expecting further reduction
Yes, my lord. As per.
in terms of that
Yes,
notice?
my lord, so-called notice, they are now going to deduct it by 10th or 12th.
Yes, sir. Whether it can be disposed of in terms of this,
My lord, basically,
or otherwise, we may have to.
no, I'll leave it to your lordship. What had happened, my lord, is that when the initial letters on 13/2/2025 at page 24 were issued, the petitioner was not the only retailer. There were other retailers also. After annexure A, my lord, there were different parties who had approached this honorable court, where lordship would see at page 31 and 36. There are different instances, my lord. The petitioner had not approached us, but that is at an admitted fact, my lord. We are not disputing on that. Now, the last communication which the petitioner preferred was on 10/6/2025, very sought for some time because there was some bereavement in the family, my lord. Then the reduction had taken place 9 months thereafter. Now, if your lordship decides to dispose of the matter in line with the directions contained in the earlier orders, my lord, I'll have no issues with that, my lord.
Otherwise, there was no action from your side, so they were also happy.
They were happy. They were happy.
Happy.
In fact, what had happened, my lord,
They
the
thought that, yes.
judgments at page 31 and 36 were judgments in personam, my lord. They're not in rem. They're applicable only to the petitioners who had come. But out of that bona fide from our part, because the first order is on 4th of April 2025 at page 31, your lordship has seen that. Thereafter, we preferred him the email at 10/6 because we wanted to extend the equity to the petitioner also by way of a personal hearing. Annexure C of
11/6.
10/6.
10/6, 11/6 was
10/6,
for hearing.
that notice for personal hearing was extended by us based on directions of this honorable court in similar writ petitions, which did not involve the petition. Now, if your lordship directs us to abide by those conditions, my lord, will be.
No, then immediately thereafter they responded, sticking time.
And we did not.
Then matter rested in such position
For 9 months.
thereafter.
For 9 months.
For 9 months.
There was no communication from them, and there was no communication from either.
According to the petition.
My lord. My lord.
According to the petition, both sides remain silent.
There was stalemate. So your lordship will direct us to carry out our exercise within the period, fixed period. There will have no.
Till then, no further recovery, my lord.
But there's
whatever has been recovered, it will be decided. This 2,84,000.
There's one small issue, my lord. My submission, my lord. The recovery which is done is not done manually. My lord, the issue what is.
Yes. So far, this already done.
The essay.
We are not saying that.
Yes.
So, any other.
My lord. Will withhold any recovery.
Because you quoted an amount of 32 lakh.
32 lakhs, my lord.
Right, in the notice.
My lord.
And you said that maximum limit per month will be 50,000.
50,000 is no 50,000 or whichever one is higher.
Whichever is higher.
Yes.
So maximum or 50% of distributor margin.
Yes, my lord.
Right. So there is some apprehension.
My lord.
Let it be.
Will withhold
till any further decision, any further reduction will. Yes. The decision taken in after hearing him,
my lord,
will abide by the decision.
And my lord, they will supply the ERV slips to us, my lord. This is not dispute, my lord. This is a basis of.
No, the ERV slips, my lord, regarding the voluminous documents, my lord, since it pertains to an effective right of the petitioner, let them approach our offices, my lord. Let them come to our offices. We'll cooperate.
We'll inspect, my lord. Liberty may kindly be granted.
We'll do that, my lord. There will be
page
my lord. 38, my lord.
38?
38, my lord.
38, my lord.
Okay.
Since ERV.
Mr. Chaudhary, heard Mr. R.M. Zeka, then counsel for the petitioner, and Mr. M. Sharma, Learned Training Council, IOC Limited, for all the respondents. Full stop. having regard to the issues involved in the instant writ petition and considering the fact that similar two writ petitions involving similar issues have already have been disposed of earlier. So this petition is taken up for consideration at the motion stage itself, as agreed to by the learned counsel for the parties. Post of para. The petition is an authorized distributor of liquefied petroleum gas LPG cylinders of the respondent IOC Limited. And it runs its business in the name of in the name of Messrs. Novodeep Gas Service. Post of the petitioner is a sole proprietorship firm. It does its business in the name of so-and-so, which is head office at Maligaon, Goshala, Gauhati. Since 1985, there are approximately 28,000 numbers of customers, LPG customers, under the petitioner's dealership. Post of para. On 13/2. On 13/2/2025, a notice was issued to the petitioner alleging violation of clause 23 within bracket small a of the INDAN quote unquote within bracket liquefied petroleum gas bracket close distributorship within bracket domestic and commercial agreement, and it was further alleged that an amount of rupees 32,54,218.58 was incorrectly given credit to the petitioner's account. In the notice, it was mentioned that while returning market return cylinder, there was a requirement to sign the equipment return voucher within bracket ERV by the representatives of the distributor and the transporter within bracket, i.e. the driver of the truck. It was mentioned that a review had revealed that credit had been passed on to the petitioner's PAD account for the empty cylinders returned, which was equivalent to rupees equivalent to 43.56 MT of LPG, amounting to rupees 32,54,218.58. So, stating that the credit was made incorrectly into the petitioner's paid account due to non-signing of the ERV slips. The said amount was sought to be recovered in a manner indicated in the notice dated 13/2/2025. But on receipt of the notice, the petitioner on 18/2/2025 sought 1 week's time to file its reply along with the supporting document. When the petitioner was informed about the date of personal hearing on 11/6/2025 by an email dated 10/6/2025. The petitioner on which date?
On the same day, my lord.
On 10/6/2025
Yes, my lord.
sought for fixation of the date of personal hearing after at least 15 to 20 days, as there was bereavement in the family of the petitioner. Post of para, the situation rested in such position with no communication. Now, according to the petitioner, the petition situation rested in such position with no communication, with no further communication from the end of the respondent IOCL Limited till 10/3/2026.
Yes, my lord.
Post of on 10/3/2026, comma, an amount of rupees 2,84,744 stood debited from the paid account of the petitioner, and it is reflected that the said amount has been debited as recovery of excess market return. Post of. It thus transpires that the recovery made on 10/3/2026 is relatable to the notice dated 13/2/2023. Post of. Mr. Dekal and counsel for the petitioner has referred to two orders passed by two orders dated
4/4, my lord.
4/4/2025
And
and
another one,
8/8/2025
my lord.
passed in read petitions WPC number 81804/2025 and 4483/2025 passed by coordinate bench passed by coordinate bench of this court. It is he has submitted that the petitioner may be granted the same opportunity as had been granted to the petitioners therein. As the demand has been made by the respondent IOCL authorities in the notice dated 13/2/2025 on the basis of ERV slips. The petitioner should also be allowed to obtain the copies of the ERVs on the basis of which the claim for rupees 32,54,218.58 has been made. Post of para, Mr. Sharma, Learned Counsel for the Standing Counsel for the respondent IOCL Limited has submitted that the petitioner the instant petition can be disposed of in similar lines. So as he has further submitted that the ERV slips might be voluminous. Therefore, the petitioner can be granted an opportunity to inspect the same in the office and to take required notes
My lord.
for the purpose of for the purpose of enabling the petitioner to submit an effective reply. Post of para. Having taken into consideration the orders dated so and so, whereby similar writ petitions have been disposed of. Principal things of the constituted that this writ petition, instead of keeping this writ petition pending, common the same can be disposed of. Right, in similar lines. Also, with the following directions. One, page 39, the representative of the petitioner shall appear before the respondent number
It's not 3, my lord.
3 on at 8:30 p.m. on
After Bihu vacations, my lord.
20th? On 20th?
20.
20 at 10:30 a.m. on 20/04/2026. The respondent number 3 shall provide the ERV slips on the basis of which the respondent corporation had issued the show cause notice dated 13/2/2025. Full stop 2. The petitioner is to be given the liberty to submit its reply on or before how much?
20 days, my lord.
20 days. Yes. 10th of May.
10th of May. By
10th of May.
My lord.
10th is Sunday.
11th
of May.
11th of May.
3. The respondent corporation shall pass appropriate orders duly taking into consideration the show cause reply if submitted by the petitioner thereupon. Full stop. 4. Till such decision is taken, the respondent's authority shall not proceed with debit stroke deduction from the entitlement of the petitioner. Full stop. As an amount of rupees 2,84,000 so and so has already been debited on the paid account of the petitioner on 10/3/2023. The return or otherwise of the said amount will abide by the decision taken by the respondent authorities on the representation of the petition.
Right. I have one small submission, madam, subject to the Lordship's final consideration. The other writ petitions were filed when the show causes were issued.
Okay.
This writ petition was filed after the recovery was undertaken. Now, my lord, I have a small systematic problem that IOCL faces here, my lord. That the recovery is not done manually. It is done by way of a system where every month a particular amount goes. Now, if that amount is to go, now the maximum that can happen before the entire matter is resolved is there might be a possibility of one more credit from the account
Take
of
an
the petitioner.
instruction to the bank, my lord.
No, bank or no, it's a system. It's a software account system, my lord. We don't have control over it. We don't run manually. We post recovery stamps into the system, and that is how a minimum, a bit by bit amount is taken off. So the stay on any further recovery, my lord, might be problematic for the IOCL. We'll carry out our utmost endeavors to finish the process and not to take any course of
It
action.
can be stalled, I think.
We'll try. We'll try.
Instructions should be issued by them.
We'll try our best, my lord. We'll try our best. That's an application, my lord. That was my submission.
David, then immediately it can be credited back.
My lord.
If it is automatic,
yes, my lord.
manually it can be credited back.
My lord, we'll do that.
Easy.
Yes, my lord. I'm grateful, my lord.
Deep job, my lord.
Item 33.
Yes.
Illegal and arbitrary action of the Dibrugarh Municipal Corporation in allowing the private respondent number 5.
When it was? When
It was
CCTV footage was not there? Or what? Yes, Mr. Lord.
Without opening any tender laws.
Huh?
Without opening any tender. The
Is this
back door-
so?
It was issued on
we'll,
13/3 today.
We'll record your submission. We cannot stall now.
But no, the tenders were not opened also.
We'll record your submission. If it is not opened, definitely we'll stay.
Without opening lordship, that how can it be possible, lordship? Without opening lordship, the tender papers.
Where have you stated?
Put in the box, lordship.
Page 9.
I'll keep it open, interim order.
Lordship.
Heard Mr. I had heard and I talked about a petition. And Mr.
Lordship, I'm for one, lordship.
K. Goel and additional senior government advocate for the respondent number 1.
Lordship.
Full stop. The petitioner is a previous lessee
The contractor
of
first three categories.
Class one categories.
Class one B category. Page 18, Lordship, this is my
a previous lessee Annexer 4 of to collect parking fee of Paltan Bazar Panchali to Radha Mandir and New Garden Road, Hillspur, Dibrugarh during the period from 3/4/2025 to 31.
that was my Lordship.
Yes, your experience.
Yes, sir.
31/3/2026. Right? Full stop. A short tender notice dated 4/6/2026 was published inviting tenders for settlement of 11 number of parking zones in Dibrugarh municipal areas. The last date of submission of bid was 21/2/2026. To stop. However, by a subsequent corrigendum dated 17/2/2026, the last date of bids, subsequent corrigendum dated 17/2/2026 and 19/2/2026. The last date of bid submission was extended to 23/2/2026. To stop. The petitioner. Oh, you are class 1 contractor also. Huh? Yes, a class 1 contractor. What like you submitted his bids in response to the tender notice dated 4/2/2026. First of all, it is the case of the petitioner that without following due procedure, as indicated in the tender notice dated so and so, the respondent means Dibrugarh Municipal Board authorities, corporation authorities have settled the tender for Paltan Bazar Panchali Point to Radha Krishna Mandir Sarali and New Garden Road, Tiyashpur, in favor of the respondent of 5. Full stop. Aggrieved thereby the petitioner's approach discovered by the instant petition. Full stop. The petition issue notice returnable on soils. Issue notice is also issued on the intent prayer. As Mr. Gogoi has appeared, except 1, no formal notice, extra copies. We need to work in this. Step 7, respond number 2, 3, 4, and 5 by speed post to it. Post.
Till then, Lordship, he may not be allowed to collect the tools.
Let him collect. The prayer for interim relief will be considered on the return.
1305. Item number 34.
Lordship, in this matter, Lordship, Senior Advocate D. Sekia is appearing, Lordship. He has been engaged today afternoon, Lordship. So I am praying let this matter come tomorrow, Lordship. In the meantime, we'll get some time to prepare this matter. Tomorrow, Lord.
Just 5 minutes, 2 minutes if you are waiting. So the issue which is arising for Lordship in this petition is whether after the tenders process has started, whether the eligibility conditions can be changed, and more particularly, when the last date for tender was over, whether after 3 weeks of that, whether the eligibility condition can again be changed, and whether the financial, the bid, the format, etc., whether everything can change, whether the bidders can be directed to file a fresh bid again after closing of the bid. 12 times the date has been extended. 3 times the eligibility criteria has been changed. Now, I don't know for what reason the eligibility criteria is again and again change must be to, my lord, prima facie, it seems that, my lord, the
Last date of bid submission was over.
over
So bids were already submitted.
submitted.
Hmm.
Now they are,
And again,
after 3 weeks, again the eligibility conditions, the forms, etc., all changed. Eligibility conditions changed, and everybody directed to file afresh.
so did you file?
Well, I will file 10th is the last.
The conditions are are made
No,
more
the condition-
stringent or relaxed?
Because I released before that this all these actions appears to be only to favor someone, so that the relaxation criteria, whatever criteria are there, when they are not suited to one, again relaxed, again 12 times, my lord, it has been, dates were extended. Second issue is that, my lord, whether when the last date is over, whether extended means something is in existence. You'll also be seen in the fishery. When something is closed, where is the question of extension? No question of extension. Extension can be done prior to, my lord, the last date, not after the expiry of the last date. That will also, our division bench has held, my lord, in the fishery rules, my lord, 12, that extension can be only prior to the expiry, not after the expiry. You know, I am not interested in that way. You know, I feel that in this case, this is a fit case, they should go for the fresh tender. Why they are doing all those things to fit one person, you know, eligibility criteria changed, financial criteria changed, submit fresh bid, again fresh.
With a corrigendum or with the extension, fresh bids mean new players can come in?
Yes. No. Because if new bids cannot come, there is no.
Right. No, then the situation has been complete. Say, last date was this.
My lord.
Say, 31st of
March. My lord.
Bids were submitted.
My lord.
All players they have submitted. Then thereafter, the corrigendum has been issued, say, on 20th of March. April, with new criteria.
New format.
And limiting the competition to the already.
Not limiting, because that's why I'm submitting. This is not limiting to it.
Allowing
everybody again.
But the bids were not open.
Bids were not open.
Not open.
Not open. But my question is that, look, how you can, by way of corrigendum in the existing tender process, if you want, you can cancel it and have a fresh. But once we have submitted our financial bid, our technical bid, everything, how you can, under which law, my lord, you can again reopen it, again, my lord, change the tender conditions and ask that you come again? That will make a mockery of the tender process. Anybody can do anytime. Your lordship has given number of judgment, my lord, the rules of game cannot be changed after in the, that is in the, my lord, in the advertisement for the selection and all those things.
We'll look into it tomorrow. Okay, I'll read it. Tomorrow?
I know, but tomorrow, my lord, in the last date, your lordship may kindly see that matter is taken up.
There are many documents, lordship, which the petitioner has suppressed, lordship.
Yes,
in fact, lordship, a request was made on behalf of the petitioner to relax the qualifying criteria, and that was ultimately rejected.
When?
That was rejected.
No, after.
And now they are apprehending that they may not be qualify the qualifying criteria, lordship.
The condition.
And that is the only reason they want fresh tender.
I will show the condition that in the pre-qualified meeting, below the meeting which he held, anybody can make any prayer relaxation, but not after the closure. Closure after there is no question at all. Prior to that, meetings are held where, my lord, the pre-bid meeting, my lord, their suggestions are given and all those things they consider it.
Where is that corrigendum?
Well, last, the impugned, my lord.
Page?
Last.
Because otherwise it will.
623, my lord.
623.
Hello.
Okay. And when is the last date? By which document we can find out the last?
That is, my lord, you'll also find 623, no? 622. 622, my lord.
last corrigendum,
My lord,
extending the time.
my lord.
So, 27 February.
My lord, your lordship may see page 623.
By 6/22, last date of bid submission was 27 February.
My lord.
Then 6/23 was issued when?
My lord, the 623 has been issued on the
20/03/2023.
20 March 2026.
So, after 3 weeks.
After 3 weeks. And your lordship may see again it says bid closing date and time extended 10th April 2026.
Okay.
And pro forma and e-pricing bid format stands revised and has been uploaded. So the bid, my lord, the pro forma financial bid also have been changed. Nothing will remain there.
And new bidders can come in.
Look, you also may see there is nothing.
If new bidders were prevented, then it would have been different.
And
I don't know about this.
Well, then also the second serious question will come that after the bid closing date, can you change any criteria for the existing ones? You cannot change it. Neither you can allow new one, nor you can allow change the earlier one. You go for the fresh.
Okay.
Instead of that, all those things, why you are doing all those things? Even if you want to favor someone, have a fresh criteria and do it.
Dr. A. Saraf, Learned Counsel, is stated by Mr. A. Borua. P. Borua, Learned Counsel for the petition present on the request of Mr. P. Nayak, Learned Counsel for the respondent oil, lays the case tomorrow.
In fact, I was trying to lay hands on your lordship judgment. Number of judgments are there on the rules of game cannot be changed. I was trying to yesterday night, I could not. Today I will suddenly.
Okay.
Not, in fact, not changed, Lordship. A request was made, that was rejected.
Let us have it.
A prayer was made for change the game, rule of the game, Lordship, that was rejected. And now they are apprehending, they may not solve it.
My prayer rules of game cannot be changed, rejected. Now they are changing it.
Lordship will see the other records also, other documents also. We'll place tomorrow. Obliged.
I'm highly obliged, my lord.
Thank you.
35.
Yes, Mr. Muto.
My lord, regarding my lord, retail outlet of the my lord, regarding issue, retail outlet, my lord, of the my lord petrol pump, my lord. So advertisement was issued, and on my lord, it is was issued on my lord 28/6/2023. And thereafter, my lord, lot was done, my lord. I was selected, my lord. And thereafter, my lord, field verification done. Thereafter, spot verification done. And after found all everything correct, my lord, LOI was issued. And after issuance of LOI, my lord, I'm getting the explosive license, trade license, and no objection certificate from Deputy Commissioner, and we commission it. And started, my lord, giving service to the public, my lord, that is on 31/7/2025. Thereafter, my lord, they issue a show cause notice, my lord. And in that show cause notice, that is also like that as per their own rule, my lord, that cannot be entertained, my lord. I will come to that, but before that, my lord, one very pertinent question here, my lord. What happened, my lord? The advertisement location at that point of time in Borpeta district. After issuance of my lord NIT, then my lord, 3 months, my lord, after 3 months, it is my lord, now it became Bozali. So now it is a new district, my lord. But
where is your reply to the show cause?
My reply is, my lord, show cause. I have given a reply.
Page 144.
Page 144. My lord, before that, my lord, I have to show on one thing, my lord. Page 75, your lordship kindly see. Page 75. This is very important, my lord. Page 75.
Yes.
Page clause 18, my lord. The grievance redressal system. Any complaint should be accompanied with so and so, and clause 1. Complaint received from the after draw of lot holding process along the requisite fee of sonship will be kept in record and investigation record after the successful completion of scrutiny and.
No, this is prior to selection process.
No, my lord, I'll come.
Now you have become the operator.
My lord.
Petroleum, you are the dealer now.
My lord, now your lordship, I'll come to that, my lord. Your lordship kindly see, general complaint with verification facts, complaint against the selected candidate. Selection candidate means the candidate who have completed the field verification of the credential successfully and is eligible for issuance of LOI. Space 76. Space 76. Any complaint received after 30 days from the date of draw of lot, holding process directing will not be entertained. Anonymous complaint without verification fact will not be investigated. These are very within 30 days you have to file. Because in my case, my lord, LOI was issued. That means, my lord, at the time of issuance, there is no complaint. Now, your lord,
dealership has been commissioned already.
my lord,
Now a contract agreement has been executed.
everything done, my lord.
Now it is only two-party. There is no third.
Now, my lord, on the basis of a third party complaint, that's without.
But it is they and you, is it not?
My lord, your lordship kindly see the show cause notice, my lord.
Let us see.
Page 131, my lord. Page 131. Second paragraph. A complaint was received against you alleging irregularity in selection of the dealership for the above mentioned location with air. My lord, anonymous complaint, no date, nothing, that is also not been supplied to me. And now your lordship kindly say what there, my lord? They said very clearly, my lord, a complaint was received, but that complaint was not supplied to me. Who has given this complaint and when given the complaint, my lord? And very interestingly, this complaint, this show cause notice was issued on when, your lordship kindly see.
It is clause 58K also.
Yes. My lord.
Clause 58K. And it's only show cause notice.
My lord, did
law regarding.
now, my lord, no, they are, my lord, without verifying anything, they are going to close down it, my lord. That's why I'm before your lordship now, my lord.
How can it be?
No, that's why, my lord, I'm before your lordship.
No, it's
Your lordship kindly examine the matter until no coercive action
No,
is
in
taken.
show cause notice, what is the law normally?
My lord, your lordship.
Was there anything?
No, they have, my lord.
Can show that it is predetermined.
Yes, my lord. They give me a hearing, my lord. I went to the Calcutta. In Calcutta, my lord, they says no. We are going to cancel
You
your life.
have written the details in a synopsis, right? And you have made out a good case. Let them examine.
Yes, my
pass
lord.
the final order.
My problem is that, my lord, if your lordship leaves them, leave them, my lord, in the meantime.
Oh, I cannot. We are because the tentative view may not be the final view.
No, my lord, if they close down it, my lord, already they have already in my, I have stated, my lord, in Bhayan, they have hear me, my lord, they says, no, I'm going to cancel it, my lord. We will not have nothing will hurt from you. And your lordship kindly.
That we cannot say what they did in the parcel hearing. But so cause notice is quite clear.
At least, my lord, I am entitled to get that, my lord, get that complaint which was filing against me. That was also not supplied to me, my lord.
If that is so, I can provide. And I can also provide an opportunity to file a detailed representation if you require, as you have averred in this petition.
My lord,
your representation may not be satisfactory. At that time, Mr. Mohanto was not there.
Not there, my lord.
As Mohanto was not there, so I can allow you.
And no, my lord,
I can still allow you to file a detailed representation.
They have collected all these things from website. Your lordship kindly see now this location. Your lordship kindly see the one of the
Mr. Mohanto, you have made out a good case in the synopsis. If that is true, then their decision might not be.
No, my lord, that
might not be good. But so cause we do not interfere in the so cause.
No,
We
after show
can
cause,
allow you effective participation.
no, I have already taken, I have
then-
effective, my lord, but you know, I have appealed.
The law is settled, I am not interfering in.
Then,
Law
my
is
lord,
settled, we am-
but any moment they can, my lord, going to, my lord, issue a, my lord.
They have the right to pass an order.
But your lordship, prima facie see that they cannot acting on a complaint which is after 1 month, my lord.
Clause 54K, I have seen in the meantime,
My lord.
in the notice. Leave aside the other clauses. 54K of the dealership agreement,
My lord.
which they have quoted.
No, dealership agreement, there is nothing wrong, my lord.
If something comes out subsequently, they can still.
No, your lordship kindly see the one of the focus, my lord, focus, my lord, is a prima facie that, however, it is noted that the advertised location was now district of Barbara, not in Bozas.
Mesco.
My lord. No, if your lordship,
Mesco Limited.
page 133, my lord. Your lordship.
133.
133, my lord. However, it is noted that the advertisement location was in the district of Borpata, not in Bozali. But now it is in Bozali, my lord.
That is what Mr. Mohanta have said, that in your synopsis and the documents enclosed with this petition, you have made out a good case. But this is to be decided by them.
But in the meantime, my lord.
Not in the writ proceeding. And definitely show cause and reply thereafter, an order has to be passed. We can observe that after basis of this, final view may altogether be different.
Already, my lord.
If law is settled, there is no predetermined thing.
But your lordship kindly see tomorrow.
It is premature. Time and again it has been said, unless bias mind is shown from the
your lordship kindly
show
see.
cause.
Your lordship kindly see that. Show cause notice. Your lordship kindly see.
I have
So,
seen.
no, that will be kindly see, my lord. The show cause
I have
notice.
seen Mr. Mohanto, unfortunately.
12/1/2025, but posted in after 1 year. Maybe it is a typing mistake, maybe from their end, my lord. How they can issue that? Your lordship kindly see 12/1/2025 issued, but that was sent to me when, my lord, I have annexed the envelope, my lord. That is 1/13.
Maybe
1/2026.
Mr. Bortagur.
No, we have clarified 153, madam. There's a minus of the partial hearing, madam. First square, madam. 153, madam. First square. 12/1/2026, madam.
So, my lord, then prima facie, your lordship kindly see how they can acting on that, my lord. And the complaint which was, my lord, the thing you started from their complaint, anonymous complaint, they have taken into account, my lord. And that too, after one month, my lord. That cannot be, my lord. Prima facie, my lord. Because their own circular, my lord. Let them answer on that, my lord, your lordship.
Oh, no. Absolutely not.
Then,
if you want a copy of the complaint and to file a detailed representation, I can allow you.
All right, then, but till then, my lord, no action be taken.
No, I am closing this.
No, even then,
I am closing this
till supplied by them.
Surely,
my lord.
the copy of the complaint, yes, Mr. Bortagur supplied a copy of the complaint.
Our problem is it's a vigilance complaint, my lord.
Whatever, we
Yes.
don't know.
Obviously, madam.
What vigilance complaint? Give the copy of
Yes,
the complaint.
obviously.
You have issued the show cause notice on that
Obviously,
basis.
Yes.
And
We
also
will
an
say-
effective opportunity of filing a reply after that.
Fine.
Thereafter, you take a call.
Yes, sir.
What a vision this is. No? Hard. Mr. T.J. Mohanto, Learned Senior Counsel, presented by Mr. I. Ahmed, Learned Counsel for the petitioner. And Mr. S.S. Roy, Learned Central Government Counsel for the respondent number 1, and Mr. L. Vertical Learned Counsel for the respondent number
2, 3, 4.
2, 3, and 4. Close stop para. The The case of the petition, projected in this petition is, in brief, is that, synopsis is our A2, para A2A, A2A, para. The petitioner has approached this court, agreed by a so-called notice, purportedly dated 12/1/2025, served upon the petitioner, wherein it has been alleged that the land offered by the petitioner does not fall under the advertised location, i.e., quote, within Mazgaon village, Borpeta district, unquote, which was posted on 13/1/2026. And same was received by the petitioner on 19/1/2026. Post of in response, Mr. Bottakul and Council for response number 2 to 5 has submitted that the said issue has been clarified subsequently during the personal hearing with the petitioner on 24/3/2026, and in the minutes therein, it has been recorded that the so-called notice was dated 12/1/2026. Full stop. Para. In response to the petition, so-called notice, the petitioner has submitted a reply on 2/2/2026, denying all the allegations made therein. Full stop. Mr. Mohanto has submitted that the complaint on the basis of which the so-called notice has been issued has not been supplied to the petitioner till date. Full stop. Referring to a number of clauses in the voucher for selection of dealers published by the oil marketing companies in June 2026. Mr. Mohanto has submitted that such a so-called notice is not permissible after execution of dealership agreement on 31/7/2025. So, on the other hand, Mr. Bottakul has submitted that the so-called notice has entirely been issued under clause 54K of the dealership agreement dated 31/7/2025. Para. By the so-called notice, the notice that is the petition has been asked to respond to the proposed action. It is, not a case, Malay. Uh, With the issuance of so-called notice, the rights and obligations of the parties have not been decided and crystallized finally. Full stop. A tentative view. The event of issuance of the so-called notice is a step towards taking a final decision in the matter. Full stop. A tentative view taken in the process cannot be deemed to be the final view taken in the matter. The final view will depend upon the grounds taken and materials received in response to the so-called notice from the noticee, that is the petitioner. And if the noticee, that is the petitioner, is able to show sufficient cause as to why no action contemplated under the impugned so-called notice should be taken, the final view may altogether be different. First of thus, this court does not find any justification to exercise the jurisdiction under Article 226 of the Constitution of India at this stage, because it is only against the final decision, not against the tentative view, the power of judicial review is exercisable. Post of para. As since the complaint is partly on the basis of the, since the so-called notice is partly on the partly on after receipt of a complaint, the petitioner should be granted an opportunity to look at the complaint. First of therefore, the Mr. Bothakur, counsel for the petitioner, respond number 2 to 5 is directed to the respondent authorities in the BPCL or
SPCL.
SPCL is directed to supply a copy of the complaint on the basis of which the so-called notice has been issued. First of the petition after the same is to be supplied within a period of 7 days from today. Preferable by email?
Yes.
Preferably by email.
My lord.
Preferably by email. Full stop. On receipt of the copy of the complaint, the petitioner should be granted a further opportunity to file a detailed representation along with all the supporting documents within a period of 7 days thereafter.
It will be 15 days, my lord.
15 days thereafter. So, and the petitioner can also seek for an opportunity to a personal hearing at the time of submission of the
My lord.
said representation. So if an opportunity of personal hearing is sought for, the respondent so and so authority shall provide such opportunity to stop. The respondents, the proceeding initiated by the show-cause notice should thereafter be brought to a logical conclusion by passing an speaking order. Thereafter, post of it is provided it is needless to mention that there shall not be any coercive action against the petitioner in terms of the so-called notice in the meantime.
My lord, deputy.
This order disposes of the writ petition.
36.
Yes, may I please, your lordship? My lord, the respondent issued a NIT, my lord, for a construction work, and
What happened?
my lord, clause 6 of the NIT stipulates that the bidder has to.
Why you waited? So many petitioners came.
Lordship,
You
and the time is over, Lordship. The
My lord.
4/4 was the
if
last
your-
date, Lordship.
If your lordship.
whether it has been opened or not.
No, it has not been opened till
I
date.
have to take this instruction,
Then
Lordship.
come after the direction, we'll say.
Yes.
We'll see thereafter.
Lordship.
My lord, I categorically state that it has not been opened till today, my lord.
No. Whether it is an essential one,
Yes, my lord.
right?
Yes,
I have examined the terms and conditions initially.
yes, my lord.
Well, I disposed of the
Lordship,
more than 10 petitions, I think.
Yes, Lordship. Lordship.
My prayer is that let them issue a site visit certificate now, my lord. And I may be allowed to submit the offline tender because it has not been opened till date, my lord. And my lord.
For
the
though page 26,
Yes,
site visit certificate,
yes, my lord.
it must be submitted, right?
Yes, yes, my lord.
One thing, on what ground you are challenging that?
I am challenging on the ground that, my lord, the respondent authorities, more particularly respondent number 3, my lord, he is deliberately not taking action.
That we
because
have
my
seen.
lord, on annexer 2,
But
page,
Mr. Bora,
page 83.
Mr. Bora, page
Yes, ma'am.
27,
Yes, my lord.
preparation of bid,
Yes, my lord.
technical bid,
Yes,
technical bid to be submitted by the bidder shall comprise.
yes, my lord.
There are document number A to R.
Yes,
That site visit certificate is not part of those documents.
yes, my lord.
So, if it's, I am indicating if your technical bid is rejected on the ground of non-submission of site visit certificate, you come.
Yes.
Because I have a tentative view.
I have submitted, yes, my lord.
Right.
Because
You submit.
Post bid closure date submission is.
my lord, otherwise, my lord, because the mala fide intention of the respondents is apparent from the document.
That is why, Mr.
On
Bora,
earlier, in respect of the same work, my lord, annexer 4 at page 86, your lordship will find, in respect of the same work, there was an earlier tender process where the petitioner was L1, my lord. So without any reason, that has been cancelled, my lord. Page annexer.
what was the last date?
Last date on 4th, my lord.
4th?
Saturday, 4th April, my lord.
With commission.
Yes, Lordship.
Yes, my lord.
Huh?
Yes,
Yes, my
Lordship.
lord.
Already
Then-
over, Lordship. That is why.
Oh, over.
Over, my lord, 4th, because on till 2nd, my lord, he was running to the office of the executive engineer.
When the tender notice was
And he has filed on 4 this
Published.
petition, Lordship.
Tender notice was issued on, my lord,
13/3.
13/3, my lord.
13/3.
13/3, my lord. He has prepared.
In the meantime, 100
Yes, my
of
Yes, yes, filed, Lordship.
My lord, if your lordship sees annexer 2 and 3, my lord, he has approached the authorities and they have received his application also, my lord.
no, after last date, what can we do?
My lord, it has not been opened till now.
So that is not the issue.
Yes, my lord.
After a bid closure date, what can
Because
direct that
till-
issue this
till-
and take it as a part of the petitioner's bid document?
My lord, then till 2nd he was
I am
waiting.
indicating to you, Mr. Bora, there
Yes,
are
my lord.
other means.
Yes, my lord.
I have indicated by taking you to page 27 or 28,
Yes, my lord, I understand. Because,
whether this is an essential document or not.
yes, my lord.
তো ফাইল করে দেয় হেঁটে কোন পাইছো দিস শুড সাবমিট
Have you understood?
Yes, my lord. Yes, I understand, my lord. But what?
That I cannot do. That issue that site visit certificate
Yes.
and open it for the petitioner, extend the bid submission date. That I cannot do.
My lord, because of these peculiar circumstances, my lord, petitioner may be allowed to submit a bid because it has not been opened.
I can allow you
Yes.
bid submission
Yes, my lord, that much.
physically.
Physical.
Yes, my lord, that much I want.
Without the side visiting certificate.
Without
Without,
site visit. You-
Yes.
Yes,
Yes,
my lord.
Yes.
Yes, my lord, that much I want,
Yes.
my lord.
The petition is a liberty.
Lots.
I am not directing anything to consider his bid.
Yes.
Yes, my lord.
No positive tag, observation.
Your lordship may allow me to.
He is a liberty, Lord.
If you go and submit
Yes.
forcefully or send it by post. Nobody has barred you. Nobody has barred you.
Second, my lord, he was running.
No,
Barred is the
Mr. Bora, I have understood every
Yes, my lord.
case.
Yes, my lord.
Already 50 similar petitions have been disposed of.
Dispose of.
Within the day, I have directed that
In fact, my
the
lord,
petitioners either to give or I am directing him to submit the bid, either of the two. And most of the time, it has been done with.
so your lordship may permit
But you
me.
did not come earlier.
My lord, till second he was
Heard
running.
Mr. B.P. Bora, D.P. Bora, counsel for the petition. I have indicated to you and Mr. N. Upaidhyay, Standing Counsel Irrigation Department for the respondent number
1, 2, and 3, Lord.
Para petitioner has approached this court agreed by non-issuance of site visit certificate to him despite requests made in writing.
Page 83 and 84, my lord.
Mr. Chief Minister is busy in campaigning.
But he has directed, my lord, Chief Engineer Irrigation to please allow, my lord. And thereafter, my lord, he approached the concerned executive engineer. Page 84, my lord, page 84.
The petitioner, in order to submit a bid in terms of a NIT dated 13/3/2026, sought for the site visit certificate as per clause 6 of the tender document, a site visit certificate must accompany the bid of the petitioner, which is to be submitted online. To stop agreed by non-issuance of the site visit certificate despite making a request in writing to the respondent number 3 on 1/4/2026. The petitioner could not submit the bid as the honor before the last date of bid submission, that is on 4/4/2026.
Yes,
Agreed by thereby come the petitioner has approved this court by the instant repetition. The matter of required examination, issue notice, returnable, so and so. As Mr. Steps number 4 by speed post. Extra copies tomorrow.
Lordship.
Your lordship may grant liberty to the petitioner to submit offline bid, my lord. Because otherwise he will be nowhere, my lord. And on earlier occasion, my lord, already he has got site visit certificate also in respect of the earlier round of tender process, my lord. So, because he was otherwise, my lord, he was.
Where is the provision for submission of physical bids?
When the authorities are acting arbitrarily, my lord, then your
We'll
lordship.
examine arbitrariness, definitely. I am
Yes,
not
ma'am.
saying that I am not examining.
Yes, my lord.
Question is permitting you to give a hard copy after the bid closure date.
Yes,
We may,
Because it has not
if
been.
the grounds is available, you have made out a case.
Yes, my lord.
Challenging this, that it is not an essential document, will definitely take into
My ground is
consideration.
not there, my lord. That is.
And
it is
then
not
I
essential
have to go by
document,
the
my lord.
pleading.
My ground is the arbitrary action of the authorities, my lord. Because if the authorities acted arbitrarily, then your lordship may allow the petition.
Absolutely, absolutely. First, for that also, even that also, I'll examine the matter
My lord.
regarding site visit certificate. But after bid closure date, I cannot allow you to.
Then, my lord, my first prayer is to set aside the tender process because of the arbitrary action of the authorities, my lord.
At the motion stage, I cannot.
No, my lord, some interim protection at least, my lord. My lord, till the next returnable date, my lord, no final order with regard to
We
the.
can make the thing early, that before election.
My lord, on till second he was running, third is holiday. On,
Returnable on 4/5/2020.
my lord, on the, in the last part of April, my
It
lord,
is same as good as same.
last part of April, my lord.
Look, one is Dusty,
Yes, my lord, I will take
Dusty,
the,
Dusty, response number 4,
and last part of April, my lord,
April last.
29.
29. Obliged, my lord.
2904. Timing matter. Item number 6.
What is to be done here?
All deleted, Your Lordship.
All
deleted. Similar matter.
Yes, yes, Mr. Law Scholar.
Press note, if my lord, their name is included in the, my lord, final list, my lord, they are eligible to cast their vote, my lord. Election Commission of India, press note, my lord.
Instruction that is, all have been, they had permanently shifted from the constituency.
We are not shifted, my lord.
Right,
This-
that is, we cannot sit here and decide. As I have already held subject to, any appeal has been preferred or not?
Normal appeal get not. 83, Lordship.
No, Your Lordship.
Huh?
Individual appeals have not been preferred, Your Lordship.
But whether my judgment has, against my judgment has been preferred or not?
After that, no.
Against my judgment,
And
any appeal has been preferred or not?
Yes,
it
my lord.
has,
What has happened?
Lordship, a notice was issued, my lord.
Notice was issued.
it's fixed.
Yes, it is as good as same thing. Whether division bench can determine all these facts, I don't know. But at least I cannot decide whether you have shifted or not shifted. It is up to you. We can dispose of the in similar terms, or otherwise we can also issue notice awaiting the outcome of the division bench judgment. We can do that.
Yes, my lord.
We'll issue notice. Heard Mr. S.B. Loskar, Learned Counsel for the Petitioner, and Ms. S. Kotoki, Learned Standing Counsel, Election Commission of India for all the respondents. Agor Perato likhi dibo. Ms. Kotoki, Learned Standing Counsel, ACI, was requested to obtain instruction as to whether the names of the petitioners are included in the electoral database. Post of today, Ms. Kotoki has submitted on the basis of instruction received by letter dated so and so of the district election officer Sibhumi that the names of all the 26 petitioners have been deleted from the electoral roll on the ground that all of them had permanently shifted from the areas under number 125 Patrakandi LS. The matter of required consideration, issue notice returnable in 6 weeks. As Ms. Kotogi has appeared accepted. No formal notice. The respondents shall ensure to file the counter affidavit on or before the return.
2505.
Like,
Production list. Item number 1.
Wait, please, Your Lordship. My lord, the petitioner in this case is again a gas agency, my lord, dealer. Now, like initially an order of suspension was issued on 21/2/22. My lord, as such, perhaps I cannot have a grievance against suspension in a sense. But if your lordship would kindly come to the suspension order, my lord, at page 21.
Okay.
Why suspension has been resorted to? falsified delivery records by showing LPG cylinder as delivered, manipulated the booking and delivery system, indulged in practice indicative of black marketing of essential
No,
commodities.
after recent crisis.
No, my lord.
After recent
Oh,
LPG
yeah.
crisis or what?
No, my lord. Then no period is prescribed.
Hmm.
Switched off the contact number of the proprietor during a period when consumers were in panic to book LPG cylinders, thereby not complying with so and so. Failed to provide the required information as and when asked for effective monitoring of supply and demand. Failed to maintain proper supply chain management and frequently entered into conflict with delivery of drivers of bottling plant located at New Gauhati and Mirza. Failed to comply with lawful directions and has not cooperated with the inquiry process. Now, my lord, at no point of time any show cause notice was issued to me or any explanation was issued to me. My lord, pursuant to this order at page 23, now, para 1, my lord, they refer to the show cause, the suspension order. Please come to para 2. In view of the above and in the interest of the esteemed consumers of the corporation of IOCL, you are advised to stop refill supplies with immediate effect. All consumers in your distributorship and corporation's equipment such as cylinder lying with you will be retrieved by the corporation's official and shifted to near. Virtually that means, my lord, now I'll be done away with.
What is this suspension? Suspension conflict.
Trade license, my lord. This is by the district authority. My lord, we will deal with this, but our anxiety starts at page 23, Miller. Because without notice, can you take this call, Miller? Because under the relevant order, show cause notice is a must. My lord, today we have filed an additional affidavit, my lord.
Yes, IOC, Mr. Borua.
We just have, because it has been suspended. Complaints are the trade license has been suspended. Once the trade license is suspended, we cannot permit the continuation of trade
Now,
license.
my lord, we have filed an additional affidavit, my lord. Now what they have done again, if your lordship should kindly have that. At 10 o'clock at night, my lord, kindly see the timing. It was served on us on mail. In pursuance of the suspension of your trade license by District Commissioner Kamrup, I dated so and so, it is hereby informed that all corporation owned equipment such as cylinder, pressure regulator lying in your premises shall be retrieved by the corporation. Said equipment will be shifted to nearby IOCL distributor as deemed appropriate. Accordingly, corporation officials will be visiting your godown and showroom for assessment and verification of cylinder and pressure regulator stock for official record. You are hereby requested to remain present at the godown premises at 10 a.m. on 7th of April to facilitate the above process. My lord, as far as suspension of my license is concerned, that is one aspect. But even that also, my lord, if your lordship will kindly have the control order, my lord. Yes, I can give that. Control order 82.
Trade license.
Huh?
License and control.
Licensing and control.
Trade articles.
Trade article.
Yes.
Yes. If your lordship will kindly come to rule 11, my lord.
No, trade articles for 9 years.
Right. Did they? Oh, look. Lord will kindly come to rule 11, order 11. Pagination is not there, Miller.
Okay, I've got it.
Rule 11, Miller, or regular order 11. Suspension and cancellation of license. if any license or his agent or licensee or his agent or servant or any other person getting on behalf contravenes any of the terms and conditions, then without prejudice in any order action that may be taken against him under the Essential Commodities Act, his license may be cancelled and an order in writing of the licensing authority and an entry will be made in his license relating to such suspension or cancellation. No order of cancellation shall be made under this clause unless the licensee has been given a reasonable opportunity of stating his case against the proposed cancellation. But during the pendency or in contemplation of proceedings of cancellation of license, the license can be suspended for a period not exceeding 90 days without giving up any opportunity to the licensee of stating his
This
case.
was similar to say clause 15.
Yes,
Same
similar
thing,
clause.
same-
Now, my lord,
exactly
my
similar.
submission is, my lord, to the extent of suspension, it was okay. But subsequent to actions, my lord, it virtually amount to cancelling my license, my lord. Now, my lord, regarding the allegations I have explained in paragraph, my lord, 7.
What is the license? What is the license?
License-
This order? Trade license?
Yes.
Because what is the nature of license under this order?
Yes.
What kind of things are dealt with?
Yes, my lord. Food, fair price, gas or something. Right. I think, my lord, subsequently, sorry, LPG must have been added, my lord. Kerosene is there.
Kerosene is there?
Yes.
Schedule, where is the schedule? It is there. Malakshun LPG আছে। Yes, LPG is there.
Yes.
Huh?
There. Subsequently incorporate position. It is there, my lord. Internet, my lord, while downloading from internet, lot of
Yes, but
mistakes are there.
My lord, actually, as per the Essential Commodities Act, the act does not specify. There are various other orders, control orders,
Right.
for spirit and height.
Right.
Kerosene order is a separate order.
Right.
This is
So here, what is this?
this the order would itself have to specify that.
Right, which order? Is it
Oh, the
trade
es-
article?
The Essential Commodities Act provides, this schedule provides the essential commodities, petroleum and petroleum products.
Huh?
Petroleum and petroleum products
Some essential.
are the essential commodities, my lord, in the act.
Schedule paisa na?
In the schedule to the Essential Commodities Act,
Schedule.
schedule, my lord. Number 1 is drug, serial number 5, petroleum and petroleum products.
Okay, see, very good. Five.
My lord.
And Mr. Borua, this is the order under which this LPG is dealt with. Because everything, seed, fertilizer, are all jute, different control orders.
Control orders.
Now, what is this? This is the article order.
This is the order for, I presume this is for a trade license, but for the storage of LPG.
That is what I am
there are
asking.
different orders.
That is under the Petroleum Act.
That is under the Petroleum Act, Essential Commodities, there's separate, there's a list of orders under the Essential Commodities Act. There's a particular list of orders. I have not, I will go through and I'll find the lordship of this order.
Now, page 21.
Yes.
Because thus I am asking for my knowledge that you have suspended the
This is by district authority.
Yes.
district authority.
Licensing
right?
authority, yes.
This is in excess of the power so and so trade license.
Yes.
Trade license.
Trade license.
Now, the subsequent line, until further order.
Yes.
Next line, the agency shall immediately cease all operations, including booking, storage, and distribution of LPG cylinders. Whether that is what I am trying to find out, whether if trade license under this particular order, Assam Trade Articles Licensing and Control Order 1982, whether it deals with cylinders.
There's a liquefied petroleum gas regulation of supply and distribution order of
So how can he pass this order?
Exactly.
Subsequent line.
Well, the license,
No. That is what I am trying to find out.
well, the trade license which is issued by the VC, but there is a trade license. Not I have.
No. He has now passed an order on LPG cylinder.
Yes, Malad.
And this is an order under Assam Trade Article Licensing and Control Order. Whether LPG, Essential Commodities Act, read with the particular control order, you have to pass the order.
Yes, Malad.
Now here, my specific question is Assam Trade Articles Licensing Control Order 1982, under which he can pass the following order. The agency shall immediately seize all operations, including booking, storage, and distribution of LPG.
Malad, the petitioner is doing business on the strength of a trade license. Malad, that trade license is issued by the DC, and he is having the trade license. Malad. The petitioner is having a trade license, and that trade license is issued under this order only.
My lord, my humble submission is, my lord, that is certainly a relevant point, whether Deputy Commissioner under control order of 82 has that power. That is one aspect. But my submission is, my lord, in the name of suspension, can these last three lines be added, which amounts to cancellation without notice? That is the point, my lord. What, end of the day, my lord, nothing remains, that means. So in effect, it's a final order. So the control order itself says, if you want to cancel it, and in effect, my lord, all that we are saying, it's a cancellation.
Let us hear Mr. Borua for the time being.
Yes.
So far as my understanding goes, without the instruction, I do not have the instruction at present. Then the order itself mentions that there is an without prejudice to further action to be taken under the Essential Commodities Act, which means the corresponding.
Which order? Deputy Commissioner order?
Or Deputy Commissioner order without relevant permission.
Nine.
The without prejudice to other remedies in case by the corporation. So far as my understanding goes, there is a clause 10 which enjoins certain duties like maintaining a register of accounts, etc. in the order of 2000, LPG order of 2000. So
What is this PR?
Permanent regulator, my lord.
Huh?
Permanent regulator.
Mr. Borua, we can only permit only cylinders, nothing else. Cylinder, we cannot. Public interest demands. Everybody, cylinders,
Yes.
only cylinders, nothing else.
this
Only cylinders under due preparation of inventory. The cylinders maybe 100, 200, whatever. No other.
But my lord, if they take away this cylinder, nothing remains, my lord.
No, all this other, they have said,
Ah.
such a cylinder, etc.
My only submission is,
And,
my lord, this action amounts to a final order. Without notice whether this is permissible, my lord.
That is what I'm
My
trying to find
submission
out.
is, my lord, this page 23 and the additional affidavit, this should not be given effect to. Page 23, let them, otherwise, my lord, but for the holidays, Lordship can call the matter on 22nd. Let them have that instruction, my lord. Especially what are the complaint against me, I must also get an opportunity. I have explained in paragraph 7 to 13 why all the grounds are, my lord, not tenable. At least this email dated 6/6 and my lord, both are 6/6, my lord.
Yes, Mr. Borua.
My instruction is that we have made also alternative arrangements so that the consumer's interests are not affected.
That's it.
So even if it is stayed or not stayed, I don't think it should affect the consumer.
Well, for the timing,
Yeah.
there shall not be any action. Will not,
No coercive action.
further examination will be after Bihu.
Yes.
Let them operate, will issue
Well,
notice.
but that is the issue as regard the email sent by the IOC to take the stock and all. As regard the suspension order, my lord, lordship suspension order as such as of
No,
now. there-
we are on page
it-
23.
Page 23.
No,
For the order of the DC,
action, no further action. In terms of no action, in terms of this 6th April 2026.
Yes.
lordship, the interest of public should not be, my lord.
He has said,
Should we-
he is taking care of it.
Lordship.
Heard, Mr. Oh.
Otherwise, my lord, under the order,
We keep it in the motion stage itself.
well, under the order, since the order of 4th of April is under challenge, this petition is not maintainable because under the order, appellate provision is there. Order 28.
Mr. Chaudhary is making specific challenge to this email at page 23.
Gotcha.
And he is anticipating some coercive action
Yes.
today itself, right?
Ma-
That is what we are.
Mal, if lordship is
And
not,
we keep it in motion stage itself.
Yes.
Thereafter we'll decide.
lordship,
We don't know about the provisions also.
as regard the suspension order, lordship is not passing any.
No,
order.
no, no.
Lordship.
Heard, Mr. Ken Shuri, Learned Senior Counsel, Estate by Mr. R.M. Decker, Learned Counsel for the petitioner, Mr. D. Nath, Learned Senior Government Advocate for the respondent number 1, 2,
And see,
and 3, and Mr. N. Borua, Learned Counsel for the respondent number 4, 5, and 6. First of the petitioner is a LPG distributor. And the appointment of the respondent IOCL, Indian Oil Corporation Limited. Full stop. The petitioner has approached this court asserting an order dated 4/4/2026 passed by the respondent number 3 under accessing powers conferred under clause 8 of the Assam Likhit page 21, read with so and so. Whereby the trade license of the petitioner has been suspended with immediate effect until further orders. The petitioner is also assailed an email dated 6/4/2026 received from the respondent IOCL, whereby the petitioner has been informed that pursuant to the order of suspension dated 4/4/2026, there has been a contravention of clause number 9, breach of license conditions, empowering the respondent IOCL as the licensing authority to suspend or cancel the license. Poster. It has been informed by the email that in the interest of the consumers, the petitioner shall stop refill supply with immediate effect, and all the customers of the petitioner's distributorship and the respondent IOCL's equipment such as cylinder, PR, etc., lying with the petitioner would be retrieved by the IOCL's official and shifted to the respondent IOCL distributors. First of the matter would require further examination. The Learned Counsel for the respondents have sought time to complete their instructions. First of in the meantime, there shall not be any action. Place the case on 22nd April. Having regard to the action contemplated by the email dated 6/4/2026, it is observed that there shall not be any action in terms of the email dated so and so. till the next date of listing. No action.
Yes, but both the sixth, my lord.
No, 6 only.
No, both are dated sixth. That additional affidavit, my lord.
Email, I said email.
Both are email. My lord. Both dated sixth, my lord.
Additional affidavit, they serve.
Oh, additional affidavit. Oh, I thought, I forgot.
Ah,
I
that-
forgot about.
Empty cylinders may.
Email dated so and so. Oh, I wrote from you. 2 emails.
My lord, may
Two
mention
emails.
the time, huh?
2 emails.
One is of say 3:40 PM
Okay.
and other is of 10:21 PM.
2 emails. Annexer. Annexer within bracket B to the repetition. And annexer C to the additional affidavit.
Yes.
Right. তাৰপিছত দুইটা email
To maintain the supply with the consumers by the others, the empty cylinders may require by the others. my lord. Empty cylinders may be required. my lord,
Mr. Bolwar is taking
Yes,
care of.
we'll take care of that.
Yes, submitted.
Take
So
care of it.
I asked the pointed question to Mr.
Lodge.
Borua. Before you, I have asked the question. He said that the IOCL is taking care of it.
And my lord, here the licensing authority is the DC. my lord. Lordship has indicated licensing authority IOC.
No, I have not touched that 4/4/2026.
Lordship.
I have not touched at all.
One.
Khata khali likhibo. Mr. Dekal and counsel for the petition shall furnish a copy of the writ petition each to Mr. So and so by tomorrow.
Lordship.
আছে তাতে আছে
নালাগে।
নাই আহিলে additional affidavit has been brought by through the court or you have handed over.
Additional affidavit. It is filed, my lord, but it is in registry.
It has to be requisitioned. Otherwise,
Yes,
there will be no additional affidavit.
Deep note.
No action on the emails.
Yes.
Say admission of the orders.
Admission. Admissions. Yes.
Yes.
Those who go back.
24 and 25 months.
Our interim orders.
Interim orders. Let us see. Let us see.
Matter of department.
Not possible today.
But interim in 26 also.
White order.
Other pointed,
Who appear for petitioner? 24 and 26, Adhor. Yeah, Mr. Adhor, the counsel for the petitioner, and Miss Ann Arbora.
2 to 6.
Learned standing counsel NHAI for the respond number
2 to 6.
2 to 6 are present. Due to paucity of time, some of the cases could not be taken up today. When do you want?
Last part of April.
Not possible?
Other.
May. Huh? Okay, short for
1305.
council for the parties. List
13.
April
30.
April. The interim order past area shall continue till the next.
29. Item number 25, lords. Similar.
Same.
24, 25.
There, I have a,
Both same order.
I have a,
Same order.
Yes.
Okay.
I have a small, yeah. What happened, lords? It consequent upon the interim stay.
I'm not going to apply my mind. At 5:15.
26 also, my lord.
Interim order has been extended, that's all.
26 also will stay on.
On the request of Mr. Morning Learning Council for the petition, list the case on switch.
The interim.
Interim order past area shall continue till the next.
Obliged.
1105.
Any? Yes, Mr. Quilter.
23, my lord, only for date, my lord, no interim.
Okay. Date list the on the request of Mr. N. Quilter and Mr. So and so. K. Gugoi, State Council. List the case on so and so. May.
1305.
Anything else?